some of the background that led up to the actual finalization of the contract. May I ask you to look at bundle 1, Denel bundle 1. You've listened to the evidence, have you not, of Ms. Malashlela, and you've also been provided with a copy of her affidavit for your comment, correct?
Yes, I have to.
And you're aware that at an early stage, according to Ms. Malashlela's evidence, she raised a serious concern about the award of the single supplier contract to VR Laser, particularly because there was no tender or RFQ competitive procurement process.
I learned that from evidence, yes, Chair.
And were you not aware of that at the time?
As I stated in my affidavit, the first time I heard about not being happy with the process followed was in the early parts of 2016, when she first mentioned this to me in the passing and said we did not follow correct procedure. I was surprised to hear that. Shortly thereafter, there was an EXCO meeting, and where I recall it was raised again. And then this was in 2016, and then she followed it up with an email to me when I was overseas, and I reacted quite sharply on an email because I thought the way she put it in the email was in a much more serious tone than what I heard it in the passing and at the EXCO meeting, and I thought that was serious enough to be discussed on a one-on-one basis or in a committee, and not writing an email while I was abroad. So yes, that's when I found out, Chair.
So you found that out only in 2016. You sure you were not aware of that in 2015 at all?
I cannot recall that. I really cannot recall that it being discussed.
But then how do you come to say that you only found out about it in 2016, if you say you can't recall if you found out about it during 2015?
I cannot recall. I would not have reacted in the way I did and stated at that time, this was 4 years ago, this is the first time, apart from raising it in the passing, it's the first time that you now officially raises it with me. So that's why I say at the time in 2016, I couldn't remember that you did. I can less so now. So
you can?
I can less so now recall that she mentioned anything of the likes to me. I heard in the affidavit that it was discussed with Mr. Chiebis. I cannot recall any of that currently.
Well, can I take you in bundle 1 to page 659? Now, this is an email from Ms. Malashlela, dated the 23rd of March 2015, so it's early in 2015, addressed exclusively to Mr. Chiebis. It's not copied into you. Okay. Can you recall if you saw this email?
I cannot recall, Chair.
Right. Is it possible you may have?
I haven't even read it, Chair, so
okay.
I cannot recall.
Yes, you would need to read it to see whether you remember having read it at some stage.
Yes, perhaps I can just read the relevant parts to the witness, Chair.
Yes.
This is what Ms. Malashlela said to Mr. Tubus. Hi, Rhiannon. I've gone through the document and I realize that you've taken out my recommendation. And now the document has the name of the supplier specified. I don't mean to belabor the point, but I'm still of the opinion that should management approve this request, DLS must go out on tender or RFQ for the appointment of a single source for the scope of work. Once we've identified a supplier that meets DLS's requirements through a competitive process, then we can appoint such a supplier for a minimum of 3 years as a single source. The specification and evaluation criteria must be sent to all suppliers listed before time, etc. Now, Ms. Malashlela gave evidence.
Mr. Kennedy, you didn't say minimum, you said maximum.
I'm sorry?
You didn't say minimum, it's written maximum, but I
Oh, I'm sorry,
as if you were saying minimum.
I'm sorry, did I misread it? I apologize.
Yeah.
For a maximum of 3 years as a single source. Thank you, Chair.
I recall this from the evidence.
And the context she gave to this in her affidavit and in her oral evidence was this. She'd initially prepared a motivation recommendation. And unfortunately, it's referred to in her affidavit but not attached, just the covering email, and it appears that the memorandum itself has gone astray. But there's no dispute between her and Mr. Tubus that she initially, when she put out the recommendation as the head of supply chain at DLS, said this needs to go out to tender. And here she is replying to Mr. Tubus, because if we look on the next page, page 660, in the middle of the page, in fact, the foot of the page, the bottom email is from her dated the 12th of March 2015. Please find the attached document as requested. And her evidence has been that was the recommendation in which she had recommended that if this is to go out on a single source supplier contract, there would have to be a competitive process. And he then replies, the middle of page 660 on the 20th of March, and he says, hello Celia, I've changed the angle that we ask for approval from Riaz. Please see attached submission, any inputs. And her response is the email that I've just quoted from, where she specifically says, I see you've changed the angle in a fundamental way. You no longer are incorporating my recommendation as head of supply chain management, whose job is to advise management on these things, that you should be going out to tender or at least RFQ to ensure that it's competitive. Now, Mr. Tubus, did he not discuss this with you, or can't you remember?
I did not see this email. I cannot recall. I recall this email from the evidence that was given recently. I cannot recall this email, having seen this email then.
Yes, but my question earlier was whether you saw this email, and you've already answered that before.
Okay.
My question now is, did he discuss it with you, Mr. Tubus? Whether by email or person to person or however?
Chair, it's really difficult to recall. He might have asked my opinion on what's my opinion, should we go out on open tender or on closed tender for that matter. My opinion at the time was, I've stated it quite a number of times, that the way to go out on open tender with something like this, or firstly, to go out on open tender is more or less impossible. To do it on a closed tender, multiple tender, is to prepare drawings, is to supply potential single source suppliers with these drawings for them to tender a price, demonstrate their capability, demonstrate their quality, and on an actual example. And
yes,
then,
I think we understand what an RFQ process involves. We've been through this a number of times before. My interest is really on the question of accountability, and who discussed what with whom, and who gave approval, and who was taking the initiative. For example, you've said in your affidavit repeatedly and adamantly, Mr. Saluji was pressurizing you to award this contract to VR Laser. He says, no, he wasn't pressurizing you. You were pressurizing him and your colleagues. And I believe that it may be of interest to the learned commissioner in this commission to know where the buck stopped. Because you as CEO have already said in great detail on the previous occasion that there was huge good reason why DLS should give a single supplier contract to VR Laser and nobody else. You recall that?
I recall that vividly.
Which seems to perhaps make sense if you were the one who was driving the process. And I think it is fair for the Commission to understand whether you were aware of this at the time or not. So, with respect to you, Mr. Burger, may I suggest you don't dwell on what is involved in an RFQ process. We know that Ms. Malashlela was saying you should go out on a tender or RFQ process. We know what those processes involve, and we know why they are there, to try and ensure a measure of competitiveness. And that is why she was promoting the idea. But it was not being picked up by management, of which you formed part. If you can't remember whether this was discussed with you by Mr. Tubis or Ms. Malashlela at the time, you must say that.
Chair, I cannot recall. Okay. I was, however, of the opinion that a process was followed a year earlier, and based on that, I didn't feel it necessary to go out on a tender again. That was my opinion at the time, but I cannot recall this being discussed.
And then the last
One
paragraph.
second, Mr. Kennedy. I wonder if they can reduce the echo noise. But I'm hoping that that won't be problematic in terms of heat. But if it's too hot, please, somebody must tell me. Mr. Kennedy, how is it like?
It is very hot.
It is very hot.
But quite honestly, Chair,
No.
it's very important you hear the evidence.
No, maybe what you can do, because it's not like I can't hear, maybe what you can do is put your mic, I don't know where it can be closer, because I was hearing you, but I wanted to improve my hearing or in terms of what you're saying. So I don't want everybody to complain about it. Maybe
Thank you, Chair.
Maybe where I am, it's not as hot as where you are. Okay, all right. But I think if you don't speak too far from the phone, from
Yes,
the mic,
I've moved
it will help
Chair.
me. Yes.
Thank
yeah.
you. I hope
Okay,
that's
all right.
better.
Okay.
Mr. Burger, can I take you to the last paragraph of this email? I don't think we should piggyback on the process that was followed for the platform hull. We should go out on a separate RFQ tender process where we invite all suppliers that we think are capable and then do such appointment. I will ask Michelle to schedule a meeting. So she's specifically saying it doesn't help that we went on an RFQ process for the platform hulls contract. And we've dealt with this in your evidence before.
Correct.
That involved 3 bids. That was the RFQ process, which was, to an extent, a competitive process.
Correct, Chair.
So she's saying, but we can't just piggyback on that because that process was for that contract, for those items, platform hulls. And as you confirmed in your evidence last time, this was for a different type of component. You can't say, well, because I've awarded you contract A, therefore you're entitled to contract B. That was her rationale. Now, does that not make sense to you now?
It makes sense to me now, Chair. At the time it didn't, but it does now.
Yeah. And in fact, in the previous paragraph, I'm not going to read it into the record, she in fact says, we should also invite LMT in this process. They should be one of the parties that we invite to bid. And she says at the end of that second paragraph, I'm not saying that the work must be given to LMT. All I'm saying is that LMT and other capable suppliers must be given a chance to prove themselves through a transparent, competitive and fair RFQ or tender process. But it was not a concern for you at this stage, early in 2015, that, that there was no RFQ procurement process being followed. It's not something you raised or were concerned about yourself, correct?
Chair, I'm running the risk of repeating myself, but at the time, I state again, I got an instruction. I welcomed the instruction. It was minuted in the EXCO minutes of Denel Land Systems. I wanted to make very sure that the engineers and the operations supported that initiative. I told Mr. Terbus that we should do this, and for that reason, he ensured that the engineers did a study and that it was supported by the study. The emails that followed, it is very clear if it's analyzed that I didn't want to sign the MOU or the MOA. I instructed them that it must be Mr. Salaji. So it's all of these things that demonstrates that this the initiative did not come from me. The very fact that in the past we used to, on lower levels, approve MOAs probably made me not focus enough and understand enough that we should have gone out on tender. In today's current scenario, we should have gone out on tender. We did not. At the time, I did not think it necessary.
This is something you may have dealt with previously, but I may have forgotten what you said. What did you think then was the process that should have been followed if the open tender system should not be followed? If you thought that was not the right process, what is the process that you thought should be followed?
100%, Chair. Prior to 2014, earlier 2010, thereabouts, I can't remember the exact date, a person like the supply chain executive, without further authority, approved single source agreements because we believed it had certain advantages for the company. If the group CEO said we should do something like this, I was 100% convinced at the time that this was within his delegation to do. I knew, and I said that my delegations were curtailed quite substantially, but I was under the impression if that gets approved by a group CEO, then it's fine. And that was my departure point, and therefore I didn't give it a lot of concern until now.
Yes, Mr. Kennedy.
Thank you, Chair. So we've just seen the email from Ms. Malashlela to Mr. Terbus, and that was in March 2015. Now we know, and you've agreed in your affidavit, as I understand it, that the MOA was signed in May 2015. You recall that?
Correct.
I'd like you now in the same bundle to please turn to page 672. Do you have it?
I've got it, Chair.
Now, this is an EXCO committee meeting minute of the 29th of October 2015. Unfortunately, it doesn't, as one normally would expect, state who was present and who may have been absent or who chaired it. May I just refresh your memory as to what it says? Paragraph 1.1. A concern was noted with regard to placement of orders on VR laser. The predicament here is that the GSCE approved this deviation from the procurement process on the following condition. Quote, under no circumstances shall products or services that can be procured from a group entity or division be procured from an external supplier or non-Denel company unless there is approval by the group supply chain executive based on sound business reasons. This is also in line with the group supply chain policy and the DLS supply chain procedure. The above provisions are in direct conflict with the MOU the DLS signed with VR Laser, where VR Laser is the sole supplier for all complex welding and machining work to DLS for the next 10 years. And there was a resolution. The committee took a decision that the MOU takes precedence over the GSCE's condition and the group supply chain policy and the DLS supply chain procedure. Committee stated also that given the, it says recent history, presumably it should be recent history, with regard to price, it should be presumably price, and turnaround time, VR was the preferred supplier with all opportunities. It was further stated that in terms of the MOU, VR Laser prices must be market related and in line with the provisions of the MOA before an order can be placed on them. Due to this reason and previous experience with VR Laser, committee felt confident that the VR Laser prices will be market related and reasonable. Celia Malashlela was tasked to draft a letter to the GSCE and explain the decision taken in this regard. Now, Mr. Burger, do you recall being at this meeting where this was discussed and this was decided?
Yes, Chair.
And the concern, the predicament that was raised in the first bullet point and the heading 1.1, a concern was noted. That was that concern or concern about the predicament was raised by Ms. Malashlela herself, not so?
Chair, I cannot remember. I know about this email. I cannot remember who said what, but I presume it was her that raised those points.
Yes. And this clearly is that we haven't complied with the group supply chain management policy because the GCSE, or the GSCE rather, Mr. Mlambo had not approved the transaction relating to whether an outside supplier rather than an internal supplier could be used. Correct. That was the concern she raised.
Correct, Chair.
Right. Now, this was raised in October 2015.
Correct, Chair.
Formally in a meeting, and it's minuted. So your evidence can't be correct earlier, which suggested, although you seem to go back on that later, that you only heard about it in passing from Ms. Malashlela only in 2016. That can't be correct, can it?
Yeah. Chair, I cannot recall the exact date. I know it was substantially later. I know there was an EXCO meeting where it was discussed. Maybe it was this one, and it was October 2015. I cannot recall.
Yes.
But as I said, it was discussed in an EXCO meeting.
Yes, and presumably this is the EXCO meeting.
Yes, Chair.
Right. Now, if I can take you back for a moment in the same bundle to page 669. In fact, let's start at 662. This is the Denel SOC Limited procurement policy, group supply chain policy. Correct?
Correct, Chair.
And that became effective, as it's indicated near the top right on page 662, on the 19th of November 2014.
Correct, Chair.
Now, if we look at page 669, clause 610(1), under the heading Intergroup and Group Procurement Contracts, 610(1) says, under no circumstances shall products or services that can be procured from a group entity or division or procured from an external supplier or non-Denel company, unless there is approval by the group supply chain executive based on sound business reasons. That's the very provision that is quoted in the minutes.
Yes.
Of that
Correct.
EXCO meeting that you attended.
Correct, Chair.
Ms. Malashlela was specifically quoting and recording a provision of the group supply chain management policy that she contended had been breached. Correct?
Correct, Chair.
Right. Now, is it correct that you had a discussion about this and you discussed it in these terms? Which one takes precedence? Does the MOA/MOU take precedence over the group supply chain policy, or the policy take precedence over the MOU/MOA? Is that the frame of reference of the discussion?
Correct, Chair.
But what did you understand, Mr. Burger, to be the status of the group supply chain management policy? Can I suggest something that I would, with great respect, suggest must be very obvious, particularly to somebody so experienced in business? And that is, you have a policy which lays down rules for the Denel group, which you must comply with when procuring goods or services, correct?
Correct, Chair.
And you do so through contracts, correct?
Correct, Chair.
So when you procure through a contract, you must comply with the rules that are set out in the supply chain management policy, correct?
Correct, Chair.
So could you explain to us, please, how on earth you came to decide in this meeting that the agreement takes precedence over the policy? Surely it's the other way around.
In my mind, at the time, there was a policy, and that policy was a Denel written policy, and that policy, the custodian of that policy, my understanding was the group CEO. So what is written here is not 100% correct in my understanding. The resolution was that our recommendation is very strong that there is a legal contract between us and VR Laser, and that legal contract must be respected. There is a conflict between the contract and group policies, and my understanding at the time was the group policies is an internal matter, and therefore can be accepted by the necessary level of authority. And for that reason, I said not to get into a legal dispute with a valid contract. The precedence should be on the contract, but we should get approval from our bosses that we can do this. So I cannot recall, Chair, that we took a decision and just implemented based on that decision. We took a decision as a recommendation to higher up, and if I recall correctly, there was a motivation that was written, that was sent to Denel Corporate Office in this regard.
Yes, we'll get to that memorandum in a moment. What I want to put to you, Mr. Burger, is that the mere fact that a contract has been entered into in violation of a policy does not mean that there are no implications. Does not mean that you say, well, shrug your shoulders, it's tough, we breached the policy, oh well, we've made a contract with an outside party and we've breached our own internal policy. That's only internal, so let's just carry on implementing the contract. Are you not aware, or were you not aware then, Mr. Burger, that government-owned entities such as Denel are subject to the rule of law, including the procurement regulations, which include your own internal supply chain management policy? And if you breach a material provision of that, it can nullify the contract. Were you aware of that at that time?
At the time, I was most definitely not aware that it was a breach of any laws. I was aware of that it was a breach of the Denel procurement policy. And Chair, I have to say, this single source agreement was not a document that was kept in a dark corner and nobody knew about it. Every single body knew about this, and including my boss at the time. And for that reason, if we did something unlawful and incorrectly, there should have been action, or there would have been action taken. So Chair, At the time, I knew about Ms. Malalehla's concern. There was a discussion. She raised her objections. There were many people sitting around the table. I was the chairperson of that meeting. I tried to summarize the discussion, and it's written in the resolution. And therefore, we went to a corporate office with the resolution. So, Chair, I've got really not anything to add to that.
Well, I think from what you have said, one of the things you have said is that at the time, you accepted that you were going to be acting in breach of this policy. Is that correct?
Correct, Chair.
But you considered, or maybe I shouldn't say this, you must say it if that is the case. What did you consider that the breach was justified in any way? And if so, what is it that you thought justified the breach of the policy?
Chair, I got an instruction to form a single source agreement with BR Lasers. The content or the objective of that single source agreement was minuted in the EXCO meetings. And I was under the impression it was approved at the correct levels. So by the same token, the very same person that signed that agreement also signed the policy, and also approved the policy for Denel. So I thought if there was a conflict between the two, it is easier to deal with the internal matter than an external matter. And for that reason, I said, I support, and it was not my decision, this was a committee decision that was minuted here. For that reason, I supported that we should uphold the contract between us and BR Lasers. But at no time did somebody stand up and say, you know what, you are going against the law here. You're not allowed to do this. By no time did anybody say that. I was under the impression it is a conflict with internal policies, and for that reason I said, and it was approved by the levels same level that signed the policy, and therefore I thought it wasn't a problem.
Did you think that the GCEO could give an instruction to anybody to actually act in breach of company policy?
It's a difficult question, and I understand why you ask it. I thought that it made absolute business sense at the time why that single source agreement existed, and therefore there were good business reasons for it, and given the good business reasons, I thought the group CEO could override the policy. I really thought so. I also agree that he cannot just do what he wants. I understand your concern. So yes, he cannot do what he wants, but I was under the impression this was for good business reasons, and given the good business reasons, yes.
But you would also accept, wouldn't you, that it is particularly people as senior as you were who ought to have found it easy to say to the GCO, hang on GCO, it looks like your instruction is in breach of the policy. Can you do that? Isn't it? It's the senior people who could find it easy to say, I know you have given me an instruction, but it looks like it's in breach of the policy. Can Can you give me an instruction to do something that goes against the company policy?
Yeah, Chair, hindsight is a perfect science, sir.
Yes, yes. And it wasn't done.
It wasn't done.
Yeah.
Not that I can recall, Chair.
Yes, yes. Certainly not by you. At
Not-
least.
not by me.
Yeah. Mr. Kennedy?
Thank you, Chair. If the policy was not a law that you didn't have to comply with, and if you entered into a contract that was contrary to that policy, well, then the contract must just still stand. What's the point of having a policy at all?
Oh,
Because it would mean that that people could, as actually happened here, go into signing an agreement with full knowledge, thanks to Ms. Malashlela, that there was a breach. She first raised the issue of no tender or RFQ process. That was rejected by Mr. Turbis. And secondly, she raised the point that you haven't got GSCE approval to go outside the divisions. But if you felt that, well, that doesn't matter because it's not a law, it's only a policy. What's the purpose of having a policy if you're not going to comply with it?
Chair, no, I think that is, with great respect, taking the point a little bit far. The policy is there to govern the organization and to make sure that good decisions are taken as a norm. But like anything in life, there are always exceptions, and that does not mean one can ignore the policy. It means, in my mind, that if you are doing something that is not stipulated in the policy, then you have to get approval at the correct level of the organization. And in my mind, this having a policy like it's better to manufacture something internally than externally, it's a good policy. I agree with the policy. I'm not questioning the policy. But in this specific case, with the problems we had, with the risks we were running, I've already indicated this would have been a good place where we have complex fabricated steelworks done. And Chair, my apology for saying it again, it is also common knowledge that to have, when you deal with highly complex things, having single source agreements is not a bad thing. It's a good thing in this complex environment. So I did support it. I supported the idea then, I support the idea now, but it does not take away that the policy is a good policy and it makes sense.
Yeah.
In general terms.
And in fact, the policy, you talk about exceptions. The policy specifically says that where you're wanting to procure something that could be procured in-house, you want to go outside to an external supplier, you have to there have to be two things satisfied. The one is you have to get the approval of the group supply chain executive, not from the divisional CEO, namely Mr. Burger, or his deputy, or his assistant, Mr. Turbis. Only the GSCE could give that approval. Do you agree with me?
I do agree, Chair, but to qualify that, I also thought, and this is how all decisions work, that if his boss and his boss's boss listened to the arguments, they had the authority to decide what is the best for the company.
Well, in fact, that approval at a higher level than Mr. Mlambo took place long after this. Didn't happen at this time. No. May I suggest we focus on the topic of my question, which is what happened in October 2015 when you were chairing a meeting of EXCO at divisional level. The fact that a year later or more, Mr. Ntsepe may have signed to say, oh, I'm not going to override Mr. Mlambo, can't, with respect, be a particularly impressive answer to explain what was going through your mind on the 25th of October 2015.
Yeah.
Do you accept that?
I accept that.
Is that fair to say?
Fair-
All right,
fair
well,
to
let's
say.
try and confine ourselves to that. You were the CEO. You were there to ensure that there was proper compliance with whatever was required. Now, here we have a situation where Ms. Malashlela is saying, but we've got a policy which precludes this. This is now the second time that Ms. Malashlela was doing her job in drawing attention to her bosses. In the first place, Mr. Tubis, earlier that year, saying, we have to go out on tender or RFQ. Otherwise, we're in big trouble. And he overrules her. It's then signed, despite all of that, despite non-compliance with that requirement of the policy, not falling into any of the exceptions that the policy itself provides for, such as an emergency situation. None of that. It's then signed, not so, in May 2015.
Correct, Chair.
And then a further problem is raised by Ms. Malashlela a few months later. There's another reason why we have a respect in which we haven't complied with the policy, and that is we never got the GSCE approval. Now, it just seems to me that the policy doesn't really have any sense or usefulness if twice in a row its provisions are breached, but management say, well, don't worry, we carry on. And secondly, it doesn't make sense why you have, no doubt at a substantial salary, Ms. Malashlela employed as your divisional supply chain management head, if twice she raises serious concerns that this is in breach of a policy, and twice she is ignored or overruled by you.
May I repeat, Chair? I reject the fact that it was overruled by me. I state again, there was a meeting held that consisted of executive members. She raised her concerns. It was discussed. A resolution was taken by the committee, not by me, by the committee, and a joint resolution was written down.
Did you?
Sorry,
carry
Chair.
on.
In this resolution, it is not minuted that Ms. Malashlela raised her objection about the decision. It was taken as a group discussion and a group resolution. And Chair, I hear what Mr. Kennedy is saying, but at the time it was an executive committee meeting, and a joint resolution was taken. It was not just, it was discussed and it was accepted.
Well, let's accept all of that evidence, Mr. Burger. But may I go back to the question? You overruled it. You say, no, it wasn't you, it was the committee. Now, if it was a decision of the members of the committee, it was not a decision supported by Ms. Malashlela, not so. She was against the decision.
Chair, in all meetings, there's difference of opinions. In all meetings.
Sorry, the principal?
In all meetings, there are differences of opinions.
Won't you just answer the question? Was she for or against this resolution?
She put her point on the table and she was against it.
Against it, right.
Correct.
So she was a minority. Was she joined by you, Mr. Burger? Did you take her side or were you against her side?
How these meetings usually happen, I am the chairperson. The chairperson doesn't say, what you're saying is nonsense. I think it should be different. How it happens, everybody gets an opportunity to state their opinion. And
I'm asking what you did, Mr. Burger. Let's not hear about how you allow other people to express their opinion.
I repeat again, I formulated the consensus view of the meeting, and that is written in the resolution.
And you supported it?
I supported it.
Right. So you were part of a collective that overruled Ms. Malashlela. Is that a formulation that you are more comfortable with? Or is it wrong?
It has to be correct, Mr. Baker.
Sorry, Chair?
The proposition has to be correct.
The dilemma I-
proposition or the question is, were you part of the group that overruled Ms. Malahlela? You have already said she put her point of view and she was against. And you have already said you were one of those who supported. So Mr. Kennedy is saying you were part of the collective or group that overruled her. Do you agree?
Correct, Chair. Why I was hesitating is I wanted to qualify. The word overruled is a very strong word. I do not recall, and maybe the other members that was in this meeting should be asked, but I cannot recall us saying, we hear you, we've thought about what you said, you are herewith overruled.
No, it doesn't have to be, the word doesn't have to be used, overruled.
Yeah.
The fact of the matter is, two views were on the table.
Correct.
Her view and the view of the other view.
Correct, Chair.
And you said, in effect, we don't agree with your view. This is the view that we
Correct,
uphold.
Chair.
Yeah.
Correct, Chair.
Right, so to go back to your point earlier that you now had a contract, whether you liked it or not, you did have a contract with an outside supplier, and you felt that the policy was really just an internal matter that shouldn't affect your relationship with the outside supplier. Did you even bother to approach VR Laser and say, guys, we've hit a bit of a problem, we're a state institution, and our internal supply chain management expert, Ms. Malahlela, has drawn our attention to two defects: that we haven't complied with our own policy. Now, we know that you, VR Laser, are a private entity not subject to our policy, but we are. And there's a problem. We need to terminate this agreement. We need to agree that we will not proceed. In fact, the very point of the meeting was, can we proceed, can we, Denel, proceed to place orders on VR Laser in terms of the agreement? And the decision was, yes, we must. So, to get back to my question, did you make any attempt to contact VR Laser to say, we're sorry, there's a problem here, can we try and resolve it?
No, Chair, we did not.
Why not, Mr. Burger?
Because I held the view at the time that it was within the mandate of the group CEO to sign something like this, and that it was a document that was done according to the policy or to the delegations of authority. I have to add, however, that the time when the arguments became stronger was the time when the press became more vocal about Gupta involvement. So the opinion of me was that that was not my place to give an opinion on that. But from Ms. Malahlela side, she was vocal on that. She did not support the idea of tarnishing Denel's name, of the link between the Guptas, and that was, in my mind, her biggest concern. And therefore, I took note of what was said. Everybody around the table took note of what was said, and the resolution was taken.
So you were aware at that stage that there was media controversy and public controversy about Denel's involvement with Gupta associates and businesses, correct?
Chair, if I recall correctly, it started in late 2015. It started surfacing. In beginning of 2016, there was quite a lot of media attention on this.
Now, you say that you thought featured more in Ms. Malahlela's approach. What are you suggesting, that she was trying to use wrongly supply chain management rules to try and get the company to stop doing business with the Guptas, or what? What are you suggesting?
I'm not suggesting anything sinister. I'm just saying that the Ms. Malashela thought it will bring Denel in disrepute. And, I mean, she was correct.
She was correct, not so. And in fact, she was also correct that the supply chain management policy was breached. You've already acknowledged that to your credit.
Yeah.
Did you see Ms. Malashela when she ended her evidence in tears? Here.
I did.
A long time after she left Denel, she still moved to tears and gave evidence that she tried her best as a citizen of this country and as an honest, loyal servant of, sorry, that's a bad terminology from the old days, a loyal employee of a state-owned corporation, where she tried repeatedly to get her bosses, including you, to comply with the policy, and you wouldn't. And she did it in the context of where there was indeed growing controversy about Denel's links with the very controversial Gupta family and their associates. And she was trying to warn you repeatedly, we must keep Denel's nose clean. We must make sure that if we are going to award any contracts, particularly to people who are associated with or owned by controversial people such as the Guptas, we must be absolutely sure in complying with our policy. That was her function, not so.
Correct, Chair.
It was a major part of her responsibility.
Correct, Chair.
And despite knowing that she had views as a professional and was not acting in bad faith, not so. You've already conceded that.
For sure.
Yes. So she's saying to you, we need to make sure that we comply with the policy. We're not complying. And twice, she gets rebuffed and effectively overruled by her bosses, and eventually leaves Denel in a state of absolute demoralization, huge financial prejudice to herself and her family, and still traumatized, as you saw when she was sitting in the very witness chair that you are sitting in now, on national TV. She had the indignity of showing her emotion, but to her credit, she did it because she felt it. Now, it just seems absolutely tragic, Mr. Burger, and I'm putting this to you just as a human being. It seems tragic that an organization which is owned by the public, members of the public, served by diligent, good faith members of the public, such as Ms. Malashela, when she does her job to earn her salary, to try and keep Denel's image good, and to keep Denel's image as a legally compliant state entity good, she gets ignored. Not least by you as her boss in Denel Land System. Do you have anything to say about that?
Chair, I'm not sure what I should say on what was
Perhaps as a human being, Mr. Burger, what you feel. May I remind you, I've taken you through this already. Your 138-page affidavit, I think it is, spends probably at least half of that saying how innocent you are, and how this has been such a terrible thing for you personally to have to go through the glare of the nation and the glare of the media, associating you with the Guptas and associating you with allegations of corruption and so forth. And I've never received a penny from the Guptas or anybody else. You protest your innocence repeatedly. But what you don't have there is an acknowledgement that you eventually gave in the witness box, which is that I actually acknowledge with hindsight now, if only I'd known before, that all of this was actually in breach of the supply chain management policy and that the policy had legal effect. And I only realize now that Ms. Malashela was correct, if only I had listened to her. Well, with respect, what I'm suggesting to you is that particularly where you as the CEO of Denel Land Systems went into such a major contract with VR Laser, knowing that they were connected with the Guptas who were under the spotlight of media attention as potentially being corrupt, you should have been absolutely scrupulous in ensuring compliance with the policy. And your suggestion on the previous occasion, a few weeks back in this commission, that you just simply didn't know about this. If only you had known, now you know, now, of course, benefit of hindsight. You knew because you were told by Ms.
Okay, Mr. Kennedy, sorry, Chair, quite a lot of statements were made and I cannot recall all of them. Just a word of correction, I did acknowledge that she was correct in her summation. I do acknowledge that. Secondly, I want to state again that she gave her inputs, and the inputs were taken seriously at the time. It wasn't just ignored. I think the word that was used. Her inputs were acknowledged and taken.
But not followed.
Sorry, Chair?
But not followed.
Not followed.
No.
Not followed after a discussion within the executive committee. It is. I never realized she was that traumatized by what happened. I was also hoping that she had due to the culture that existed in Denel Lane Systems, she really felt part of Denel and wanted to do the best for Denel. I accept all of that. And
do you feel any regret? Just as at the level of a human being, as to effectively her career was wrecked at Denel. It's effectively what she was saying to the chairman last time. Took some months to try and maneuver her financial situation so she could be at a point that she could actually leave, totally demoralized and heartbroken effectively.
yes,
And
Chair.
again, you say, well, I didn't realize at the time. There's a lot you, rather naively, to put it mildly, seem not to have realized at the time.
Yes, Chair. Having looked at her and seeing what she's gone through, of course, I feel deeply moved. If one takes cognizance of my own affidavit and the circumstances in which I left Denel, I can truly sympathize with her. My situation was very similar, so I can really sympathize with her.
Was it really similar, Mr. Burger?
Say again?
Was it really similar? You breached the procurement policy in important respects, despite the fact that she was telling you don't breach the procurement policy. Is that truly similar? Who was right and who was wrong?
She was correct, Chair.
Yes.
But
So are you playing the victim then? You're saying, well, poor her because poor me. That's effectively what you seem to be saying.
no, Chair, Mr. Kennedy is laying words in my mouth. I am saying I can sympathize with her because I had a scenario that over years, responsibilities, accountabilities.
Hang on, Mr. Burger. If sympathizing with her is important to mention, you can deal with it later. I think Mr. Kennedy's question is not directed at sympathizing or anything. I think what his question is directed at saying, knowing what you know now, one, that you were part of those who approved acting in breach of the policy, despite her making it very clear to all of you that this would be in breach of policy, and even quoting what the policy says. And bearing in mind how you know she must have felt at the time when all of you in that meeting didn't or rejected what she told you, and knowing how she felt, because you have seen how she was moved to tears when she was giving evidence before me when that issue arose again. Are you able to say, do you feel that you should, or all of you should actually apologize to her for making her feel like this on something that at least now you see was quite clear? or is that not the position? I don't want you to say you apologize if that's not what you feel. Okay, but what is quite clear, and I think you acknowledge that at least as of now, I'll go back to the question of what your knowledge of the policy at the time, because I wanted to go back to that. But now you acknowledge the policy is quite clear. The policy is quite clear.
I do.
And you were part of those who made a decision that was in breach of the policy, despite that, the fact that she brought the policy to your attention. And we know how she felt about this, because we saw how even years later when she was testifying, how she was moved to tears when she was talking about this. What do you say when you now look at the whole picture about the fact that you were one of those who rejected what you now see was the right advice as to what should be done?
Chair,
and bearing in mind that you were the CEO of the division.
100%. Chair, I cannot take away the frustration and the objective I wanted to reach, to have various suppliers of good competency delivering with quick turnarounds to Denel lane systems, and I cannot take away the feeling I had then, and I still have today, that all things being equal, VR Laser was a good company to form a single source agreement with. So that is on the one side of my emotion or my my feelings. On the other side, she was correct. She was correct. The mere fact that VR Laser is today bankrupt, doesn't exist anymore. It was a bad decision in taking what happened up to now. So if that decision was such a good decision at the time, then Denel should be delivering hulls now at 4 a month. That did not happen because they are bankrupt. So for whatever reason. So that emotion is also in me, that if only I had a crystal ball and only I could look into the future. The one thing I can say about Ms. Malashela, I had huge respect for her. She was, work ethic was extremely high, and her recommendations were always based on what she thought was the best for the company. I, however, at the time expected that from everybody, not just her, everybody in the division. So Chair, I can only acknowledge, the facts are the facts. The whole single source agreement and the whole agreement today is a mess, and it is to the detriment of Denel. So therefore, she was obviously correct in her assessment, and I acknowledge that. But there was no way at the time for us to have known that.
Well, there was a way, Mr. Burger. One is, you read the policy, or she quoted the policy, and you didn't see anything in the policy that said that the group CEO could override the group supply chain executive, isn't it?
No, Chair.
There was nothing like that. And you were aware, were you not, that in terms of the policy, generally speaking, will make rules and will also state where there are to be exceptions to the rules, were you not?
Correct, Chair.
So in other words, the policy tells you this is the general rule, but in certain circumstances you can depart. And it tells you if you have got to get approval from somebody else in order to depart from the general rule, isn't it? You knew that
Correct,
in terms of
Chair.
the policy.
Correct, Chair.
And in taking the view that the group CEO could instruct you to do something in breach of the policy, you didn't check the policy whether it allows that, did you?
No, Chair, I did not.
And that was not right. You should have checked. Particularly because of your position as the CEO of the division.
No argument, Chair.
Yes.
You're right.
Yes. Okay. Mr. Kennedy?
Thank you, Chair. May I take
Just one last point in regard to that. I said I was going to go back to the question of your knowledge of the policy, because I had a little bit of some concern, because last time you testified, I think the idea that you didn't have much knowledge of the policy seemed to loom large in your evidence. Is my recollection correct? That to a very large extent you seem to be saying, I'm not a supply chain management policy person.
Yeah. Chair, I understand that when you are CEO of a division or a company, one should know what's in the policies.
Yes, that's what I wanted to come to, that one of your duties must be to uphold the policy of the company.
Correct, Chair.
And if you are serious about your duties as CEO, you are going to make sure that each time you are going to make sure that you know the policy as much as possible, and where you are not sure, you will consult it, and where you are not sure, you could even ask for legal advice, isn't it?
Correct, Chair.
And none of this was done.
No, Chair, it was not. But I know that should be the case. One should study the policies and one should know the policies. These policies, this specific policy also changed every so often, and I was really focused on growing the business and not being a bureaucrat and making sure that all policies were being adhered to. At the time I was focusing on growing the business, having meetings with the clients. And I was away a lot of times from the company, traveling abroad. So it's a mistake. It's a fault on my side, but that was what the situation was at the time.
Mr. Kennedy.
Thank you, Chair. Chair, may I now ask the witness to turn to page 824?
What page?
824.
X24.
824.
824.
824,
Okay.
correct.
Thank you. Is that this, which bundle, the one we are using? At
Yes, the
moment?
same bundle one.
Okay, all right, 824.
Now, this is a memorandum that was sent by Ms. Malashlela to Mr. Dennis Mlamba, the supply chain executive at Denel head office level, dated the 29th of October 2015. Correct?
Correct, Chair.
And that was sent on the instructions of EXCO,
Correct, Chair.
following on the meeting held just before this memo was sent. The one we
Correct,
just
Chair.
looked at the minutes, correct?
Correct, Chair.
Yes. And you will have heard from Ms. Malashlela's evidence that she complied with the instruction, although with some misgivings. And she said that the top of page 825, I request permission to implement the EXCO decision in this regard. Now, that was the majority decision taken by you and your colleagues on EXCO, with despite the disagreement of Ms. Malashlela.
Correct, Chair.
Right.
Correct.
Now, of course, we've seen in this memorandum that has been dealt with at some length by Ms. Malashlela and Mr. Mlambo that she's referred to the previous indication by the group supply chain executive that products such as these should be sourced in-house unless there was a good reason to depart from this. And then in the second paragraph, she actually quotes the group supply chain policy, the very same quotation that she had given in the earlier document that we've looked at, that it has to be approved by the GCSE if you're going outside the group, and he or she as the GSCE can only give such a decision based on sound business reasons.
Correct, Chair.
So she was alerting him to that, and then she says in the third paragraph on page 824 that DLS in fact had already signed, this is in May, so that was 5 months earlier, DLS had signed an MOA with VR Laser for the scope of work. It then refers to the BBEE credentials, and it refers also to provisions of the MOA relating to prices being market related, etc. And then she says, the last paragraph on page 824, due to these contradicting positions, if I might stop for a moment, that's a contradiction between the agreement and the supply chain policy, correct? Is that
Correct.
what you understand?
Correct, Chair. That's how I
Supply
see it.
chain approached DLS Exco to make a decision as to whether to honour the MOA and place the order on VR Laser, or to follow the supply chain policy and procure from intergroup, namely DVS or LMT, for this project. Given the time frame, urgency and history, Exco has recommended that the work be done by VR Laser. And then she concludes with the passage I've already read. Now, of course, we know that Mr. Mlambo refused to give the approval that she was requesting here on behalf of Exco. And we see his handwritten note under the blank area where it says approval. He refused to sign it, and then says in his handwritten words, NB, DVS and LMT must submit proof that they cannot meet the requirements prior to the contract being awarded to VR Laser. He then signs it. Now that was then overruled later by Mr. Nsepe as Group CEO, or perhaps acting Group CEO as he then was. Correct?
Correct. Correct, Chair.
Now that was some time later. What happened before Mr. Nsepe signed, as we see here, to say he's approved, in other words, he's approved the stance of your Exco that you must honour the MOA with VR Laser. Something else happened, and that was you attempted to persuade Mr. Mlambo to give his approval. Is that right?
If you say so, Chair.
Well, I don't want to invent anything. To be fair to you, let me take you to page 837. If you can't recall, this may jog your memory. 837, it's just a few pages further on. Now that is a letter from you on the Denel Land Systems letterhead, and we see in very small print that the date is the 29th of April 2016. Do you see that?
Yes, Chair.
And that's, in fact, a letter that came from you. Is that your name and signature on page 838? Correct?
Yes, that's my name.
Now, this is what you say in your letter. Firstly, thank you for the constructive meeting held at DCO with Mr. Odwa Mshlowana and yourself on the 28th of April 2016. So that was a meeting you attended, is it?
Correct.
I confirm our discussion that a single source supplier agreement, hereinafter referred to as the MOA, was entered into with VR Laser on 19 May 2015, pursuant to a motivation being submitted to DCO. The motivation was recommended for approval by both the Group Executive Business Development, Mr. Zwelake Nsepe, and the Group Chief Operations Officer, Mr. Jan Wessels, whereupon it was approved by the Group CEO at the time, namely Mr. Riaz Saluji. The approval by the Group CEO of VR Laser as a single source supplier is in accordance with Regulation 16 capital A 6.4 of the National Treasury Regulations 2005. Copy of the approval dated 22 April 2015, the signed MOA and the applicable National Treasury regulation is attached, marked A, B, and C respectively. Now, you've indicated that around this time you were not fully knowledgeable about the law relating to public procurement and what exactly applied, whether this was lawful and so forth. May I suggest to you that you seem now to have acquired some knowledge, because you're here referring to, whether your reference is correct or not is something Mr. Mlambo deals with later, but you suddenly here seem to know quite a bit about the National Treasury regulations. You in fact quoting the specific clause of the regulation, 16A 6.4 of the 2005 regulation, and you then attach it. May I ask you where you got that knowledge from? Had you had that all along, or I see you smiling. Had somebody enlightened you, said you asked for somebody to assist you on this?
Yeah. In matters like this, I would not have the knowledge, Chair, and I still don't have the knowledge. But I, if I remember correctly, this letter, in all probability, I would have requested the head of legal at Denel Land Systems, Mr. Nees Governor, to
assist you on that.
To support my, in all likelihood, yes.
And let's just get the context of this. We know that Mr. Mlambo had been sent for his approval the recommendation we looked at a moment ago, saying that, will you approve what has been done? Can you recall if he had rejected his approval at the stage you had the meeting with him and then your letter? Was he still deciding it, or was it after he'd put in this handwritten portion on page 825?
Chair, I really cannot remember that. What surprises me here, this letter was written in October 2015, the first letter. I cannot remember when he wrote his note. I do not know when Mr. Ntsepe approved it. This letter is 6 months later, in 29 April 2016. So,
yes.
I can remember frustration,
yes.
Lots of frustration that I can remember. But
on your part or on his part, or both?
Both, probably.
Both, yes.
Both, probably.
You knew there was a problem, not so?
Yeah, oh, yes, for sure.
Yes. Okay, let's see what else you say in your motivation for him to give approval.
Well, I'm sorry, Mr. Kennedy, before you proceed, Mr. Burger, you say that this reference to Regulation 16A 6.4 wasn't based on your knowledge. You spoke to somebody.
Yes, the
head of
legal
department.
supported
Yeah.
me in writing this letter. Yes,
Yeah.
I'm pretty convinced. I'm not saying 100%.
Yeah, but I would have thought that if it was not based on your knowledge, but based on what you had been advised by the head of legal, your letter would be couched in those terms to say, I've been informed or advised by the head of legal that actually it's regulation, blah, 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 that you wouldn't present it as your own knowledge, because here it's presented as your own knowledge. Would you not agree?
I agree, Chair. Yes,
Yes.
you're right. I agree.
Yes. Okay, Mr. Kennedy.
Thank you, Chair. And you didn't refer in your letter to the fact that Ms. Malashlela had already raised concerns about non-compliance with the policy, not so? On the contrary, you were saying this can be done in terms of the National Treasury regulations.
That was my impression at the time, yes, Chair.
I see. Well, let's carry on at the foot of page 837 with what you said to Mr. Mlambo. As indicated during the meeting, and in terms of the above-mentioned approval, presumably the GCEO's approval that had already taken place. Is that right?
On the October one. Are you referring to the October one?
I'm looking at the letter at page 837.
Yes.
And I'm looking at your last paragraph at the foot of this page. As indicated during the meeting, and in terms of the above-mentioned approval, What approval were you referring to there? It seems to me that you were probably referring to the approval given by Mr. Saluji.
So
Yes.
the single source agreement, Chair.
Yes. And then you carry on, the rationale for appointing VR Laser as a sole supplier was based on inter alia the following. One, its unparalleled expertise on fabrication of complex engineering systems, which includes but is not limited to turrets, outer shields, add-on armor and vehicle hull structures. Two, it is a key supplier and strategic partner to DLS. Three, it offers the best value, having inter alia committed to invest capital and resources in the facilities in order to ensure that the capability remains intact and available to DLS for a minimum period of 10 years. Four, it is prepared to assist and has assisted DLS with its obligations to foreign jurisdictions such as Malaysia in transferring skills relating to its manufacturing process, hereinafter referred to as intellectual property, IP. And five, it promotes a black industrialist entrepreneurial company within the defense industry. Now, these are all reasons why you felt strongly that VR Laser was somebody good, worth appointing, not so?
Correct, Chair.
Yes. But Mr. Mlambo's concern was not so much as to whether VR Laser was good at its job. Mr. Mlambo's concern was the supply chain management policy says that before we go outside the group, there has to be a good business reason why we go outside the group. Not is the outside supplier a good supplier, but why can't we use our in-house suppliers? Now, presumably, if it'd been presented with reasons that the in-house entities such as LMT and DVS did not have the capacity, that would have constituted a sound business reason. But none of the reasons you're putting forward here had anything to do with that. Not so. You're just simply saying, VR Laser are great. Correct?
I said VR Laser is great, and we have got an agreement with him.
Yes. And then you conclude your letter after paragraph 5 on 838. It is hereby recommended that the attached submissions relating to the fire compartment module, FCM, and the outer shield, Mark D and C respectively, be sourced with VR Laser in accordance with the terms and conditions of the MOA. So you understood, as I read this letter, you understood that although there was an MOA, you were going to have to go through the process of trying to persuade Mr. Mlambo to place orders under the MOA for these two categories of items. You would have to give his approval.
Correct.
Not so. Can you explain why you made no attempt to actually address the real problem, which is why you couldn't source them from LMT or DVS? I'm not asking you why you couldn't source from those. I'm asking you why you didn't even raise that point in your letter. Because that was the point of concern to him, not so.
Yeah. One should, the letter is probably not complete, you are correct. The point we wanted to raise was we've got an agreement and they are a good company to have an agreement with.
Well, that you did say in the letter.
And that was my main thrust of the letter.
But his only thrust of his concern was you haven't complied with the supply chain management policy. If you want to comply, you must ask me, the group supply chain executive, for approval as to why we shouldn't give the contract to an in-house entity, which at that stage was LMT and DVS, correct?
Correct.
And to do that, you have to satisfy me as GSCE that there are good business reasons for sending it outside the company. So all you have given him is, well, we've done an agreement with them, seemingly suggesting, well, if we've done an agreement and it's in breach of the policy, well, tough. And secondly, well, VR Laser are great guys. With respect, it doesn't actually address at all Mr. Mlambo's concern, which seems to me to be a valid concern.
You are right, and I also did not go through the whole argument of why
You didn't go through any of the argument that Mr. Mlambo had invited you to give. Why should you go outside the group entities? Why should you go outside? You didn't address that at all.
Yes, I was trying to say, Chair, the reason I did not do that was because I didn't also write a long story about the DVS was not a fabrication house. Yes, they did make hulls in the past, and also the frustrations and the technical failures we had with other products we placed on LMT. So I did not go through those arguments. At the time when we wrote the letter, we thought we'll get approval based on those arguments.
Well, you see, Mr. Burger, there may be a concern here that maybe we are seeing what may have been a pattern. Ms. Malahlela raises concerns, valid concerns, and she her views, her concerns get rejected on what we all now, including you, accept were not valid grounds. Mr. Mlambo also raises concerns about procurement policy, and there is a long letter from you written to him. But in this long letter, there isn't a response to his point. So one begins to say, excuse me, one begins to say, how could it be that such legitimate concerns, when such legitimate concerns were raised by certain individuals who were very concerned about ensuring that the policy of the company was followed, how is it possible that each time you didn't see their point of view? How is it possible that you didn't respond to the actual concern in the case of Mr. Mlambo? So one begins to ask that question. Do you want to say something?
Chair, yeah, I cannot argue with you. The long and the short was there were different camps.
Yes.
And Ms. Malashela and Mr. Mlambo both felt that VR Laser was not the right company to place the order on. I have to qualify what I'm saying now. Ms. Malashela strongly supported VR Laser in the early days in 2014 to the middle of 2015. It then changed, and it was clear that Mr. Mlambo and Ms. Malashela was not in support of VR Laser doing business for all the reasons given. The opinion I had at the time, it had more to do with what's going on in the public domain than what their capability was. And never could anybody say, well, they're not good at what they're doing. Everybody agreed they were good at what they were doing. So there were different schools of thoughts. And from my perspective, I thought it was a good idea. And therefore I supported it. in hindsight, you are absolutely right. I should have written a letter that is more biased. The risk of doing that and was if I write a motivation that says, because of all these policy reasons and all these governance reasons, it's better to go to LMT or to DVS than to VR Laser. I'm sure that he will not support the idea. I knew what his position was. It was not a surprise to me. I knew what his position was. Therefore, I tried to put the relevant issues on the email. But in hindsight, Chair, yes. I mean, it's...
So you, from what you are saying, it seems you are saying to me, maybe the reason why your letter didn't address his stated concern was because you may have been trying to address not his stated concerns, but what you believed was him being against VR Laser.
Correct, Chair.
Yeah, but not the point that he had raised, because he didn't raise the merits, as it were. It was the process.
Correct, Chair.
And one would have expected that at the level at which all of you operated, all of you would have known, including yourself, the difference between the process and the merits of a particular supplier. To say when the objection is to the process, let's address the process. You can't say let's breach the process because this supplier is such a good supplier. It doesn't work like that. The process is there, and you only depart from it if the policy allows you to depart from it, isn't it?
Correct, Chair.
Yes. Mr. Kennedy?
Thank you, Chair. I want to pick up with something you said a little earlier, and that is you were aware of the sensitivity arising from the media controversy concerning Denel's doing business with VR Laser and their links with the Guptas. Now, if it is true what you have said in your affidavit repeatedly, that you were aware that the Guptas were linked with this, you were aware that there was this controversy, but to link you with any wrongdoing is just completely inappropriate, because you were simply trying to do your job objectively and honestly in the interests of Denel. Surely it would have made sense for you, especially when Ms. Malashlela and then at group level Mr. Mlambo had both raised repeatedly real concerns about non-compliance with procurement procedures. It would have been at least expedient and sensible for you to say, gee, Burger, I think I need to protect myself to make absolutely sure, because this is something that could well backfire. The spotlight of the media and the public and possibly courts and possibly commissions in the future may be looking at all of this, because there is so much controversy. I've got to make sure that I'm squeaky clean on this. And yet you go against the guidance, the very strong advice of the two experts, the one in your division who was part of your own personnel, as well as above you at head office. And you seem to have just thought, well, I can ignore what they say. Isn't that really what you were doing?
No, Chair. I have to repeat the time when this became public knowledge and became a real problem was more or less around when this letter was written.
Exactly.
It wasn't prior to that so much in our faces. So it was only later on.
I'm sorry, I'm not sure if I understand your earlier evidence. You raised the concern about the media controversy in the context of the earlier memorandum from Ms. Malashlela that we looked at some time back. Not this correspondence between you and Mr. Mlambo as late as April 2016. You in fact gave evidence that you believe it was in the latter part of 2015 that the media controversy was becoming so intense. And that was in the context of her motivation dated the 29th of October 2015. Do you remember your evidence?
No, correction.
Was that?
Correction,
was that
Chair. It is true that we became knowledgeable about the press situation. I cannot recall saying it became intense at the end of 2015, but I do recall around middle of 2016 it started getting intense. But I knew about it at the end of 2015. Yes, I did. But it wasn't intense at that stage.
The point remains, though.
Yes.
Whether it was intense or pale, whether it was light or heavy intensity, you were aware at this time that the media was scrutinizing in the public domain with some measure of real interest. In fact, you've suggested that they went really overboard with exaggerating and distorting the facts and so forth. Surely your alarm bells should have been ringing. I, being the CEO of a state-owned corporation, must make sure that my operations are squeaky clean in complying with legal requirements. And here you are twice told by supply chain officials, Ms. Malashlela and Mr. Mlambo, you can't do this. And you've been telling the chairperson, as I understand it, well, you thought you could do it. They were telling you you can't do that, and still you went on ahead. And now you acknowledge to the chairperson, with the benefit of hindsight, you know what, they were right all along. It's just a bit mystifying. Can you perhaps explain?
Yes, Chair, and I'm running a big risk of repeating myself, which I don't want to do. But we went through a process wherein the highest authority in the company supported this, gave instructions to do this, and for all the reasons I've given, we thought it was a good idea. We also had the scenario which I explained about the press articles in India, where single articles can really influence the future of a company, and I did state earlier that that made me realize that I should not pay too much attention to what's going on in the press, and that we should do what is the best for the company. And I've tried to do that. Yes, both Mr. Mlambo and Ms. Malashlela did raise their concerns, but this was at a later stage after the agreement was signed. So I had an option. I had an option to cancel the agreement based on the media and Ms. Malashlela and Mr. Mashlambu, or make sure that it is supported by Denel. And as I've said on numerous occasions, the whole media coverage was not done at a divisional level or the image of the company. That was done by corporate. And I said, we have here a valid agreement. I'm not sure on what basis I would have cancelled it. And for that reason, I supported the agreement. There was a valid agreement. In my life, in Denel, I always thought Denel employees were very good at the initial stages of partnering with people. And my opinion was always that that early stages of partnership was a good time. But when the going got tough, Denel didn't always honor their commitments to their partners. And I wanted to make sure that if we have a partnership agreement with somebody, that we do our bit to uphold the agreement. So that was in my mind always. I never, ever, and I say this again, thought that there was a conflict with the law. That never passed my. I was under the impression this was supported by the group. There were people, both Ms. Malashela and Mr. Mlambo, that did not support it, and therefore I wrote these letters to say, please approve it, and if it's not approved, then high authority must take the decision.
I'd like to pick up on one point that you made, that higher authority approved it. And it is so that Mr. Saluji signed this. But the chairperson has all the evidence before him as to which version applies to which witness. But of course, Mr. Saluji's attitude has been, well, I wasn't alerted by Mr. Burger about issues relating to non-compliance with the supply chain management policy. So I assumed that he was doing the right thing. He was the one who was pushing me, Saluji, to expedite the approval and signature of this process. You, on the other hand, say, well, I thought that although I knew Malashlela and Mlambo were against this on the basis that there were breaches of the supply chain management policy, I, in my wisdom, thought, no, they're actually wrong. And, well, it should be fine because the group CEO has been persuaded to sign it. So obviously he must be happy. It just seems it's sort of passing the buck back and forth, isn't it, Mr. Burger?
Correction, Chair. The group CEO was not persuaded to sign the agreement. He gave me instruction to sign it. And all the evidence with supporting documentation is there to prove that he gave me instruction to do that. So it was from that perspective.
Do you at least accept this, Mr. Burger, again with the benefit of hindsight, which, as they say, always gives you 20/20 vision, that it's not particularly surprising that where you went into a contract, one of 3 contracts within the Denel group, 2 of which you were actively involved in, you went in knowing that you were doing business with VR Laser that had a good track record under its previous owners, had recently been acquired by Gupta Associates, was part of the Gupta group, where you knew that there was press media controversy and so forth, and where there have been questions raised subsequently as to compliance with the correct processes. Now, isn't it something to be expected by you as a CEO, looking not only to making the best business decision, but one which, as part of being the best business decision, should take into account image protection, avoid reputational damage? And the Commission has heard considerable evidence from various witnesses as to the terrible damage that has been done to Denel and its ability to trade successfully, exploit the opportunities that are otherwise available to it. There's been devastating impact on Denel's image. And that largely arises, so the evidence has been, and your own evidence seems to be to this extent as well, that there has been huge controversy in the media and in the public domain about the links between Denel and VR Laser and its links with the Guptas. It just seems, in retrospect perhaps, you can accept that it makes sense that people are wondering, how did you give a contract like this to VR Laser in the first place? And why did it happen that this was done by your own admission now, in breach of procurement policies, by your own admission now, in the face of specific advice to the contrary given by your colleagues Malashlela and Mlambo? And do you accept that there's some sense to the fact that people are raising the sort of questions that I'm asking you here? Because if it was just so genuine and bona fide as your affidavit has repeatedly tried to make out, how could it come about that at least 2 contracts involving you were given to VR Laser Services, where by your own admission there have been breaches of policies? And you expect the chairperson and the nation to believe, well, that has nothing to do with the fact. It's a pure coincidence that this happens to have involved Gupta associates who have been involved, according to other evidence, in numerous other acts of corrupt and illegal activities.
I cannot speculate on behalf of corrupt and illegal activities, Chair. What I can say is that the passion and the beliefs I had then are the passion and beliefs I still have today. I cannot speak on behalf of other people and on behalf of the Guptas. I don't know them. The problem here is that it is so much easier to distance yourself from this mess, and I would not be able to live with myself to say it wasn't me, it was my boss that instructed me to do it. I didn't want to do it, but it was him that instructed me, and by doing that, clear my name. I'm trying to bring across what actually happened, and if we can take one little step back, and I'll cover both of them now. The Hulls contract was not supported by me; it was supported by everybody in Denel Land Systems, all the senior personnel. And there's emails to prove that. The single source agreement was supported by all the executives because they thought it was the right thing to do at the time. Yes, Mr. Maslambu and Ms. Malashlela did raise the concerns and they did say these things. But at the time when we're in the trenches fighting the fight, we really thought that was the best thing. And it was not my opinion, it was the opinion of all the executives in the Denel Land Systems. So that's the first point. The second point is, looking back, it's a mess. The place is bankrupt and they're not producing any hulls. So obviously, I wish I could turn back the clock and say, let's try and do it in a different way. For sure I would have done that. The one thing I would want to say, however, is the reason why this is a mess is, for whatever the reasons, whatever the association by their owners, they could not have a bank account, and they are bankrupt as a result of that. So too is LMT bankrupt today, not because, or in business rescue, not because we did not place a whole contract on them, but because they could not execute their orders. So whatever decision I would have taken at the time, be it VR Laser or LMT, I would sit today and say, I am sorry that I took that decision. It would have been the wrong decision because both instances would not have been able to produce the hulls. So with the benefit of hindsight, Chair, I wish I could have it differently. I wish I could have done it differently. For sure I would have. But at the time, I had a certain opinion, and I'm reflecting that opinion I had then. And I did not change my opinion from then to now for whatever reasons there are. I'm saying this is what actually happened.
If your opinion was that neither LMT nor DVS had the capacity and reliability to be able to produce these items. Why didn't you bother to say that to Mr. Mlambo? Because that's exactly what he was asking for. He was saying, give me a good business reason why we can't keep this work in-house.
Yes, Chair. You will recall that just a little earlier I sent him a very long email with 10 points or something that I said LMT cannot be trusted to do this. So that's, I didn't repeat it again. DVS was in my mind, not a fabrication house. It was a vehicle assembly plant, so it was for me almost irrelevant. So, yes.
Now let's look at Mr. Mlambo's response on page 838. 838.
838.
He says, this is again his handwritten response. Instead of signing where it says approval, he instead leaves that blank and simply writes in handwritten form, NB 1, the evidence on how VR laser was selected is not available to support its appointment as a single source supplier. 2, the approval process of the MOA excluded supply chain, and the reasons thereof have not been furnished. Let's stop there. That is true. Supply chain at head office level was never consulted before the MOA was signed at your request by Mr. Saluji, not so?
Correct,
Right.
Chair.
And he's saying, still, this is now almost a year later, almost to the day, a year later, 29th of April 2016. The MOA was signed, I believe it was on the 15th of May 2015. He says, I still don't have any reasons why we were left out. You've never given those reasons to him, have you, Mr. Burger?
No, I haven't, Chair, apart from saying, please discuss this with your line management.
And then paragraph 3 says the recommendation is given the fact that Denel executives committed the company to place orders on VR laser for specified products for 10 years to have the same executives approve future orders. Paragraph 4, the paragraph in Treasury regulations that has been cited in the motivation memo is irrelevant because it was not impractical to test the supply market. As I understand that, that is a reference to Treasury regulation that you have referred to on the previous page. Is that right?
I understand, sir.
Regulation 16A64. Now, as it happens, can I ask you to turn to page 719? As it happens, Mr. Mlambo, same bundle, has, for the convenience of all of us, in his affidavit, quoted the Treasury regulation. 719, paragraph 6.16. This is what Mr. Mlambo says. Dealing with your submission to him, he says the submission further states that VR Laser Services was appointed as a single source supplier in accordance with Regulation 16A 6.4 of the National Treasury Regulation, Regulations 2005, which reads as follows. If in a specific case it is impractical to invite competitive bids, the accounting officer or accounting authority may procure the required goods or services by other means, provided that the reasons for deviating from competitive bids must be recorded and approved by the accounting officer or accounting authority. Now, his response to your point, going back to page 838, says that this paragraph has no bearing on the matter because it wasn't impractical to invite other competitive bids. In fact, he says in his paragraph 617, I believe the National Treasury regulations were applied incorrectly. In the case of DLS, there was no need for a deviation request because there was no emergency involved. In instances where there was no emergency, DLS was supposed to go out to the market to establish if there was no other company apart from VR Laser that had the requisite capability and capacity. That process was not carried out. If at the time of approval of the MOA it was brought to my office, I would have disagreed with the rationale behind the MOA and rejected it. Now, Mr. Burger, again, you accept that Mr. Mlambo was acting in good faith?
Yes, I do.
And you accept that that was part of his duties, to highlight if there were any breaches of the procurement policy?
I absolutely do, yes, Chair.
Yes. Now, what did you do in response to his response that we've received?
Sorry, Chair. I say again that there were differences of opinion. It would have been my understanding, because what he's saying is cancel the agreement with VR Laser.
He doesn't actually say that expressly in his words. Did he say that in the meeting?
No, he's saying that it's not in what you read now. The agreement is not really valid, should not be valid. And there was a difference of opinion, and as I've said before. So, from my perspective, if he felt so strongly then as he is feeling today, I would have expected, because he was on all the emails that came from VR Laser for late payment or non-payment, he was also copied. I would have also expected him to raise this issue with his bosses, to say, we've got a dilemma here. This is a problem. I suggest we do the following. Go into negotiations with VR Laser, tell them that agreement is not valid. Let's try and get it behind us, and let's do it according to proper governance. I would have expected that to happen. That never happened.
Isn't it a bit unfair on Mr. Mlambo and a cop-out on your part, Mr. Burger? Why point a finger of blame at Mr. Mlambo? Mr. Mlambo was also emotional. He wasn't brought to tears, but you could see he was very emotional in his evidence too. And he gave evidence that he acted in a particular way as he did. And ultimately, he too was demoralized to the extent that he then gave up an otherwise very impressive career at Denel. Why criticize him? My questions are directed at you. You are sitting in this witness box. Now, you say there was a difference of opinion.
Correct, Chair.
Yes. Now, let's assume for a moment that both of you were acting completely in good faith. You were both acting honorably, and you both had a genuine belief in your respective opinions. My question was that elicited your last answer, where you've pointed finger of blame at him, was why did you not respond to Mr. Mlambo's response to you? So let's look at this difference of opinion. For example, the regulations, Regulation 16A 6.4 of the National Treasury Regulations that you had now become aware of.
Hang on, Mr. Kennedy, I'm sorry to interrupt you. There is a question you formulated in a certain way earlier. I'm very interested in Mr. Burger's answer to that question.
Yeah.
What did you do in response to this? After you received Mr. Mlambo's response, what did you do?
Chair, I cannot recall. I think we had a discussion and agreed to probably, and I'm guessing now, probably agreed to disagree. But I cannot remember what we actually did about this.
Obviously, having read what he said at page 838, you realize that he was saying that the Treasury regulation on which you relied was irrelevant. You realize that that's what he was saying.
Correct, Chair.
Yes. And one would have expected that if you were genuinely engaging in a discussion to try and see exactly what the correct position is, you would have wanted to look into that issue. Why is he saying it's irrelevant when I believe it's relevant? Isn't it? That would be the natural thing if you were really interested in establishing, is his point of view the correct one, or is it my point of view that's correct? He has now said something that I was relying on is irrelevant. You would want to look into that, isn't it?
Chair, I did not.
You did not, yeah.
I did not.
But you accept that that is what one would have expected from you, and it did not happen.
No, it did not happen.
Why did it not happen? Because this was, if his point that that regulation was irrelevant was valid, it could have made a big difference in the view you took, couldn't it?
It could, yes, Chair.
Yes.
It probably would have.
Yes, but why didn't you pursue that and even go and look at the regulation yourself, or go back to the head of the legal department and say, Mr. Mlambo, an expert in supply chain management, says this regulation you told me about is irrelevant. What do you say? Because if he is right, this might change my whole view. Why didn't you go to the head of the legal department and say that?
Yeah, I didn't analyze it as you are analyzing it now, Chair. It was, for me, at that time, and this is a year of negotiating on starting with the whole contracts, going through the single source agreement, going through these other agreements. I knew very well what his position was. He did not support the single source agreement. Whilst there were many others that did support the single source agreement, I was not, in my mind, equipped enough to have a legal argument with him with regards to what is correct and what's not correct in the PFMA. The feedback I got numerous occasions was that the PFMA is sometimes we strangle ourselves too much with the PFMA, and there is room for more flexible decision making within the PFMA, and for that reason I didn't even try to venture there, because I knew I would tie myself up in knots if I had that. And I also stated earlier that he was very knowledgeable on these facts, and I accept that. And but at the time, I can only say what happened was I got his feedback. It wasn't such a big surprise to me, and it confirmed that he was on the one side and we were on the other side.
Yes, you see, precisely because you acknowledge that he was very knowledgeable on these matters. It is precisely because of that one is surprised why you didn't say, look, this person who is very knowledgeable in these matters is saying this regulation is irrelevant. I must therefore take his view very seriously, because he may be right, or he's probably right. And so I'm concerned as to why, despite you knowing that this is somebody who is knowledgeable in these matters, and if we go back to your evidence that you didn't know much maybe about these matters, all the more reason why you would be expected to take his view very seriously before there was any finality, and if necessary, get some advice from other knowledgeable people, but at least go back to the head of the legal department and say, hang on, here is a supply chain management guru here, says this is irrelevant. We can't take his views lightly. Tell me why he's wrong. You understand that?
I understand, and I take your point, Chair.
Yes, because now I would expect that you would agree now that when you look at that regulation as he has quoted it, He was right, was he not?
Yes, Chair.
Yes. Mr. Kennedy.
Thank
I
you.
know I interrupted you, but I thought you had asked an important question that needed to be answered.
Indeed, thank you, Chair. Mr. Burger, the learned chairperson asks you why you didn't go to get advice, and it would have made sense. If you'd gone and got advice from, for example, as the chair has suggested, from the head office legal person, and the head office legal person might have felt, well, let's bring in an attorney or an advocate, as often happens with entities such as this. We have internally two different views. Which one legally is correct? We get objective, independent advice. If that had been on your side, if the advice from senior counsel or whoever, or from the head of legal at head office had said, in fact, Mr. Burger's right, the regulation 16A, 64, whatever it is, actually did apply here. Mr. Mlambo is right, is wrong, Burger is right. That would have vindicated you, not so.
Correct, Chair.
Yes, would have protected you, it would have made you look good. If on the other hand the advice was no, Mlambo is correct and Burger is wrong, then the advice would have been, this is what we need to do about it. At least you would have looked good in this sense, that you would have been accountable and showing initiative and saying, well, we've got this difference of opinion, as you put it to the chair a moment ago. Let's have somebody determine which of us is right. And whoever is found to be wrong is then told that they're wrong, and we can then move on and take corrective action. But here you seem to have done nothing. May I ask you, Mr. Burger, what was the point of you asking Mr. Mlambo for approval if when he refuses to give approval and gives his reasons for rejecting approval, you then do nothing? Surely there was a problem here. That's why you were asking for approval. If you felt relaxed about this, you wouldn't have asked him in the first place, not so.
It's not about feeling relaxed. It's about the process dictated that we should get his approval for.
Yeah.
for
You needed his approval. You knew
Correct.
that you needed his approval.
Correct.
You knew why. Why did you know that you needed his approval?
Because I know the delegations of authority.
Yes. So now he doesn't give you his approval. So you have a problem. You now know, at least by now, you may not have known it previously, if in your lack of knowledge previously you weren't aware that it was necessary, but at least by now you knew that it was necessary. That's why you ask for it. And you put up some reasons. And he comes back to you and says, your reasons are not good enough. They're not relevant reasons. They're not persuasive reasons. I'm not going to approve it. But you don't do anything to deal with it. Is the answer perhaps not simply this, that at a pragmatic level, the reality was the CEO had already signed it? So if Mr. Mlambo was saying, well, this was done improperly, irregularly, and he's not going to approve it where you knew he had to approve it, well, tough, we'll just carry on. Was that what went on in your mind?
I've stated in my affidavit a couple of times, Chair, that I was frustrated with the decision-making at group level. It's a frustration I cannot hide. It was there. I was also frustrated with in my mind, the lack of guidance and the number of stumbling blocks we experienced when we brought things like this to head office.
Sorry, lack of guidance by whom?
By people like Mr. Denel Mlambo. So,
But he was giving you guidance.
no, I'm saying
He
in
was
general.
not giving you guidance. He was giving you guidance,
I understand.
which you just refused to
I
comply with.
understand, but and this was a build-up over a long period of time. So, to answer your question, I was frustrated. I do not take that feeling away, and it was there. And maybe there is some truth in what you're saying. In the back of my mind, I said, I hear you, I take note of what you're saying, but you know what, the document is approved by the Group CEO, I will not place orders without approval, but I will probably take things like this to higher levels of authority.
Sorry, you will not take orders without approval. Is that
No,
what you
I'm
said?
saying we will, if he rejects something like this, we will not just place an order.
Yes. But isn't that what you did?
I can't remember.
Didn't you place orders after this note was issued? Or did you write or speak to VR Lays and say, I'm sorry we can't implement this contract. I want to. I think that Mr. Mlambo is being difficult, but I'm sorry we can't place orders.
Chair, you're talking about the single source agreement?
Yes.
Okay. Now, I'm referring to separate orders on the back of the single source agreement. So we went through the process. If it was within a certain level of delegation, we would take it to the Group CEO. So, but you asked me a question earlier. Wasn't it a feeling of it was approved by the Group CEO? And I'm trying to give context to the fact that maybe there was an element of truth in that. I was frustrated, and I felt, look, go and talk your troubles out with your boss, your Group CEO, and give me guidance. I was frustrated.
I'm interested in the issue about frustration. And of course, the law does cause complications and frustrations for business and government officials. But the law is the law. Now, you used a phrase earlier, and I may have misheard it, but I think you said you felt that we were often strangling ourselves too much with the PFMA. I'm not sure if the note that I made of your comment is quite correct, but is that what you were saying or meaning?
That was the opinion held by certain legal people that said many organizations sometimes act too conservatively, and because of acting too conservatively as a result of the PFMA, misses opportunities that there might be, and that the PFMA is more lenient than what we think. That was opinions people gave in the passing, like for instance the legal people within Denel Lane Systems. So I'm not saying that is what I thought. I'm just saying.
Well, can I ask you what you did think? You were frustrated. You knew that Mr. Mlambo and Ms. Malashlela were giving you advice based on their expert knowledge of the PFMA, the National Treasury regulations that you were now so happily quoting from, and being told by Mr. Mlambo, you've got it wrong.
Yeah.
So were you saying, well, I didn't respond to Mr. Mlambo, and I didn't take it higher. I didn't take it, for example, to the group legal advisor to get a properly considered view because I was frustrated.
No, I would not have received this and done nothing. I just cannot remember. I in all probably had a discussion with the Group CEO and say, what must I do?
Mr. Burger, may I suggest to you that if you did in fact do something, you would have remembered it.
Yeah.
This was surely a major issue. You had now been advised and decided that it was necessary to get the approval of the group supply chain executive, because that approval was necessary in terms of the supply chain management policies, and that you had to get it in order to process further orders. Correct?
Correct, Chair. And if the impression I held was the group supply chain executive needed in all accounts needed to be consulted, I was under the impression that if a higher authority listened to both sides of the story, they could make a call, a judgment call, what is the right thing to do or not to do. That was my thinking at the time and my impression at the time.
And
I'm sorry.
Chair.
I may I might not have heard you correctly, Mr. Burger, but I thought when you made the comment about being strangled, I think that's the term you used by the PFMA, I thought you said we sometimes felt that, I don't know whether you said we strangle ourselves or we're strangled by adhering to the PFMA. Did I not
Sorry, Chair,
understand
that was a different point.
Yes.
I was responding to getting his sign off on orders or not his sign off on orders.
Yes,
But,
okay.
but to your point,
Yes, yes.
I'm reflecting
Yeah.
on discussions we had in executive committee meetings where it was stated that people may sometimes make too big an issue of the PFMA and that it is not so rigid as what certain companies or divisions might think it should be, and that there is room for decision making within the PFMA. It's just a comment I made to
Yes,
say
but,
that.
But the reason why I'm raising is that Mr. Kennedy subsequently asked you whether that's what you had said, and he seems to have heard it in the same way as I think I did, namely that when you made that remark, you were saying you thought, by which I understood you in the company, thought sometimes, I don't know whether you said you strangled yourselves or the PFMA strangled you.
Yes.
But later on you said it was an opinion held by some people. I don't know whether you said
Yeah,
in the
it
legal
was-
department.
Yes.
And you said it was not an opinion held by you. So that's why I'm going back to say,
Okay.
I thought I had you to be including yourself as one of the people who felt that sometimes the PFMA strangled you or you were strangled by the PFMA. So I'm checking whether I did not hear you correctly to be saying we as opposed to other people.
I think, Chair, you heard correctly. Let me try and rephrase it to be absolutely clear. There were discussions within the Denel Land Systems Exco. There were views held that some by different people, also by legal people, that sometimes we apply the PFMA too strictly and strangle ourselves in doing that. The arguments put on the table during those discussions, without knowing the PFMA, without sitting down and studying the full implication of the PFMA, I supported that view because it made logical sense to me that the PFMA should not be that rigid. So you can also include me in that discussion because I supported that view. What was clear to me at the time was there were differences of opinion on how to interpret the PFMA. And that is why I refer, my legal person supported me in that letter that I wrote to Mr. Maslambu. I referred to those paragraphs. But Chair, I just want to say something speeding as an example, and sorry to do that, is very clear. It's very unambiguous. You drive at 60 kilometers. You're supposed to not drive it faster than 60 kilometers. If you drive faster than 60 kilometers and somebody catches you, you will be caught and there will be a fine. Very unambiguous, very clear. What I've come to learn in the last weeks and months is that I was wrong. I was wrong in the sense that the PFMA isn't so flexible. The PFMA is actually fairly clear. And if I reflect back, I would say it is like a Formula One driver trying to win a race within the Road Ordinance Act, trying to win a race. And the law is very clear. You're not supposed to drive faster than 120, whatever the case may be. If he complies to the rules of 120 kilometers an hour, there's no way he can win a race. But there's very good reasons for 120 kilometers an hour, because if you let everybody drive it faster than 120, there will be chaos. So I understand that law, but in my mind, we were operating in an environment where quick decision making was necessary, where sometimes you have to drive faster than 120 kilometers an hour, and for Denel to succeed successfully in the international market, I am tempted to say that it's going to be very difficult under the PFMA laws that I understand today, which I did not understand so well then, but which I understand today. And my advice would very strongly be, it's for the future of Denel probably better to operate under a more privately owned scenario. And that's just my opinion, Chair. But that's the only way I can explain it.
Yes, but I must put this to you, that it seems, as I understand your evidence, that with regard to whether you were one of those who held that opinion about being strangled or strangling yourself, it seems that when you made the remark, you may have included yourself, but later on when you were answering a question that Mr. Kennedy put to you, you seem to have said that was not your opinion, it was the opinion of others.
No, sorry, I didn't state it clearly enough.
Hang on, let me finish. But when you are answering me now, I understand you to include yourself. Now, I'm not sure, I just want to make sure that I've understood you correctly, but this is how I've understood you.
The second one, Chair, the last.
Your answer to Mr. Kennedy.
Correct.
You were not including yourself. You did not hold that opinion that sometimes you strangle yourself, you strangled yourselves, trying to comply with the PFMA. That's not an opinion that you held at the time. Is that what you're saying?
No, sorry, Chair. I'm battling to express myself.
Okay.
I'm saying it was opinion held by people that we are too critical on ourselves when applying the PFMA, and it was discussed in meetings, and it was opinion I also held at the time that we were strangling ourselves.
Okay.
In the way we were applying the PFMA.
Yes, but did I understand your evidence correctly that when you were answering Mr. Kennedy, you had said it was not your opinion? That's what I want to check. Did you say that to Mr. Kennedy?
What I tried to say to Mr. Kennedy was I was not knowledgeable enough on the PFMA, so I could not form an independent opinion I didn't study the PFMA. However, and that's why I said it was not my opinion that I put on the table to be part of the argument. It was an opinion that I shared when there were arguments on the table that said we are strangling ourselves with the PFMA. I supported the fact that we were strangling ourselves with the PFMA, but I did not actively put arguments on the table from a point of knowledge and from a point of expertise.
Well, there may be some inconsistency, but Mr. Kennedy, you
May I proceed?
Yeah.
Thank you, Chair. Mr. Burger, I'd like you to leave aside Bundle 1 now. I'd like to go back to Bundle 10, which contains your affidavits.
Well, Mr. Kennedy, we are at 4:30, and certainly from my side we can continue, but maybe we need to agree at what stage we might take a short break, and maybe we could take it now, or maybe we can still go on until 5 and take it from there, also depending on the witness, if he might need a break.
Chair, subject to your guidance, I'd be happy with a break, but may I suggest respectfully that we finish this particular topic with the last few questions?
Yes.
And then take a break, because I was going to
Yes.
ask in any event for an opportunity to chat with my team
Yes.
members to see what other issues we want to
Yes.
raise. We're getting very near the end.
Okay. Now, if
I
we
would
are
hope
close-
that we'd be finished by 5 o'clock in any event.
Okay, so maybe if you think we might be finished by 5 o'clock, then maybe, unless the witness or his attorney needs a break, maybe we can just go on. Mr. Burger, you don't particularly need a break now?
I'm happy,
You're
Chair,
fine.
I'm fine.
Are you fine?
Chairman, I'm also happy to proceed.
Okay, all right. Then let's proceed then.
Thank you, Chair. What I'm suggesting is just to complete this line,
Yes.
which should take about 5 minutes.
Okay, all right.
No more, and then take the break then.
Okay, all right.
Thank you, Chair. Mr. Burger, please turn now in bundle 10 to page 720. Have you got that?
We are now
Yeah.
back in bundle 10,
Yes, Chair.
yeah, and it's page
720.
720.
This is part of your affidavit, and it's a section where you were dealing with a response to various questions that had been put to you in writing by members of the investigation team. Is that right?
Correct, Chair.
And in paragraph 162, the question that you've quoted in italics that comes from the investigators reads, why you proceeded with giving VR Laser work as a single source supplier even after the group executive supply chain refused to grant approval on the grounds that the process was flawed. So this is the very question that I was putting to you earlier, and I just want to pick up on something, a couple of things that you've written here. I'd like to start, if I may, with the foot of the page, 1623. We're going to come back to the earlier ones in a moment. 162.3, you say, since Mlambo reported to the executives at DCO, who again reported to the group CEO, I expected that in the case of dissatisfaction, he would have taken the matter up through the appropriate channels. In other words, that Mr. Mlambo should have raised it if he was dissatisfied.
Correct, Chair.
You didn't feel it appropriate that you should raise it. You simply left it to him because he was at head office. Is that right?
That is correct, Chair.
And then you continue from a DLS perspective, however, there was a memorandum of agreement in place. However, regardless of the MOA, the delegations required the DCO approves contracts beyond 20 million rand. This was one of the contracts presented to the Executive Supply Chain Committee and were discussed and approved at various levels. If the group CEO took note of Mlambo's input and for good business reason decided to disregard his input and approve the submission, then I would imagine it was his right and authority to do so. Now, at this stage, the group CEO was Mr. Ntsepe, correct?
I presume you're referring to the...
Mr. Ntsepe, isn't it? Not Mutsepe. Was it
Mr. Ntsepe, yes.
Yeah,
I'm
Zwelaki Ntsepe.
correct.
Yes, he was group CEO, correct?
Correct, Chair.
Yes. And he, in fact, did overrule Mr. Mlambo in the note that we've seen
Correct, Chair.
that followed Mr. Mlambo's concerns. So am I right in understanding you felt at divisional level if Mlamba doesn't like what I'm doing, and he's already given his reasons for that, he can raise it higher up than himself, and that's what he did.
Correct, Chair.
Yes. But would you agree that it's not right to imagine, as you suggested here, it was his right and authority to uphold uphold your approach and reject Mr. Mlamba's approach if that was in breach of the law? You would accept that the group CEO can't do something unlawfully.
I agree,
Right.
Chair.
Now, just while we're here on the previous page, 1621, you say the first insinuations that the process was flawed only came to my knowledge in 2016 when Malashlela mentioned something to that effect to me. This coincided with a large amount of negative press for the Gupta family. Mlambo and Malashlela, by the same token, made no secret that his or their dislike for VR laser was based on his or their perceptions formed by the media and not because of the performance of VR laser. Now, you've climbed down a fair bit on what you've said in this affidavit, in your oral evidence, both last time and this time. Mr. Burger, may I ask you, do you stand by this statement or do you want to correct it? Because these are very serious allegations that you're making against Mr. Mlambo and Ms. Malashlela, that they had some antipathy and some antagonism for, as you put it, a dislike for VR laser based on their perceptions formed by the media.
Chair, I actually said it 15 minutes ago that my opinion was that Mr. Mashlambu did not particularly support the contract because of the shareholding and the ownership of VR Laser.
Did he say that? Or is that something you just inferred from what he was doing?
I cannot remember his words, but maybe it was something that that is how it was projected to me.
That's not in any of the words that we do have in front of us, in the documents, for example, that we've looked at a moment ago. He raised a number of concerns that you've now acknowledged are legitimate, based on the provisions of the supply chain management policy. Nowhere do you see anything like, I don't think we should be doing business with shady characters at VR Laser who connected with these shady characters called the Guptas. Nothing remotely about that. So where did you pick that up from?
As an example, when I received a letter from Ms. Malashlela when I was overseas, this letter I'm referring to here in the first paragraph, that was for me the first time I saw in those bold words, we've got a really big problem here. The discussion I had with her, and in my letter of reply, I felt fairly strongly that she knew that a mistake was being made. I also felt that, and probably if I did exactly the same thing as what she did, I would not be sitting here today. But I felt that she wrote a letter in such a way that she does distance herself from that deal. And then when I had the discussion on my return, and I listened to her giving evidence, and she said, well, nothing really happened in that meeting. I can actually remember that meeting very well, very vividly. And the discussion was not so much on the process. The discussion was on the image and the position of the Guptas and the effect that could have on the company. That was what and my view to her was, and I did action that, was the image of the company is really there's a department within Denel that looks after that. and should be handled by them. So I'm making these comments because of meetings like that, Chair. Mr. Mhlambu also made no secret about the fact that it's going to be bad for the reputation of Denel if we continue with these agreements. So that is why I made these comments. Having said that, Chair, the arguments put on the table by both Mr. Mhlambu and Ms. Malashlela on their opinion about the application of the PFMA, the policies of Denel and so forth, are all very unemotional, valid reasons, and I cannot fault that. And I take that point very strongly. I'm reflecting on how I felt at the time, and so to put it in perspective, looking at the affidavits, yes, I think they're logical, unemotional points being made.
Yes.
Why did you say that at Denel there was a separate department or unit that looks after the image of the company? What was that to say? It was something that none of you should concern yourselves with in the context of the contract.
Chair, there was a public relations department. I can't remember exactly what it was, or media communication, something. I can't remember the name of the department that dealt with the image of Denel and that dealt with interaction with the press.
Yes, but what I mean is, am I correct in understanding you to have taken the view that the discussions or engagements that you were having with them should not bring in issues of the image of the company because there were other people whose job was to concern themselves about that? Is that what you meant?
Chair, very much so. I mean, I was told in no uncertain terms by the then group CEO that this was not a domain I must concern myself about, and so the legitimacy of contracts because of media or threat of a media scandal was not something I really concerned myself about at that time, and I tried to explain how the delegations and the accountabilities moved to head office during that time. So yes, I truly left that to the group CEO as well as the media department to deal with that.
So was your attitude that it didn't matter how much having a contract with a particular entity could potentially tarnish the image of Denel? It was fine for all of you to approve that a contract be entered into with such an entity because the group CEO said, don't concern yourselves about the issues of the image of the company.
Chair, yes, of course I was concerned about the image of Denel. I still am.
I would have expected you to be.
At the time, there was much speculation of what's right and what is wrong. in 2020, it's much easier to.
Well,
to
I'm not
take-
sure whether it's in 2020, Mr. Burger, because this was 2016,
Yes.
3 years after the landing of the Gupta aeroplane at Waterkloof. The Gupta jet landing at Waterkloof happened in 2013, around April. So this was April 2016, this was 3 years later.
Yeah, correct, Chair.
And my recollection and the evidence that has been laid before the commission in regard to that landing has been that the whole country was shocked that a private jet or an aeroplane hired by or owned by just some private people, foreigners or citizens or whatever they were, could be allowed to land at Waterkloof. And there was a big issue in the whole country. And for some people who might not have taken notice of the Guptas or the influence that they appear to have within government, that was the moment that made them sit back and say, so what's happening? Now, I'm a little surprised if in 2016 you would not have been quite aware that there was some negativity, at least in terms of in the public domain, about the Guptas.
Yes.
Or you accept that there was some negativity. It's a question of how much negativity there was.
Yes.
By 2016. Actually, I see that you say in paragraph 162.1, that is page 720 of your affidavit, this coincided with a large amount of negative press for the Guptas. So by then there must have been, in your own view, quite some negative media attention surrounding the Guptas.
Absolutely, Chair.
Yes.
Chair.
Now, I would then have thought that it would have been a matter of concern to you and either senior people at Denel or DLS to conclude a contract with an entity that was connected with people who enjoy that negativity about them, because if Denel concludes a contract with them, Denel's own image and reputation may be severely damaged. They may be seen as friends to these people. And why would that not be something that you would think seriously about, to say, what are we going to be doing to the image and reputation of Denel if we conclude a contract with people who are so closely associated with the Guptas?
Chair.
So what I'm putting to you is that I would have expected this to have been a matter of serious concern to any senior person within a company, particularly at your level, and especially when it was being pointed out by other people within the company, because you do say that some of the people were concerned. One of them, Mr. Mlambo, I think you said. Even though in regard to this point, he might not have raised that, but you say there were other discussions from which you knew, as far as you are concerned, that he was concerned about that.
Yes. Chair, I state again, obviously the image of Denel is and will always be of importance to me. Number two, Denel is operating locally and with foreign governments in a very much political environment. I soon in my career took a position that I do not want to pick sides, and I do not want to have an opinion on what is politically correct or incorrect. And that attitude, I must be honest with you, served me well for a fair amount of time, but it caught up with me. The dilemma of picking political sides is that sometimes you are in and sometimes you are not in, and you, as a result, lose your job as a consequence. So I early on in my life, I said, I just want to be a businessman. I don't want to pick political sides. Therefore, while I acknowledge the image was important to me, I also did put my head in the ground a little bit when it came to these things. And you're right. In hindsight, I should have stood up and said, no, we cannot, you cannot do that or whatever. But I felt at the time this was the best company to do the job, and I did not concern myself with a political scenario. Now, I call it political scenario because it really relates to who they were supporting politically and not. So I honestly didn't. I looked away from those things, and in hindsight, maybe I should have concerned myself more with it. But that really was a scenario.
Well, you may have looked away, and you may have decided at some stage you didn't want to take political sides. But there is always what is right, and there is always what is wrong.
No, you're right.
And leaving aside political sides within the context of the Guptas, the negative press that you talk about here was the press that was saying they were involved in acts of corruption. It was the press that was making all kinds of allegations, and I accept that it was allegations at that stage. We'll see by the end of the work of the commission where we are with that, but it was allegations that they were involved in corruption. And I would have thought that when it came to allegations such as that, you would be concerned to say, it's not a question of taking political sides. It's a question that I don't want Denel to be associated with an entity against whom there are all kinds of allegations of corruption. You understand?
I understand fully, Chair.
Yes. Okay.
I did not take that view
You
at the
did
time.
not, yeah. Mr. Kennedy?
I'd like to just ask one follow-up question before we ask for the stand down.
Yes. Yeah.
And that is, even if you had answered that question, asked that question, and even if you had decided it was in the interests of Denel, despite the fact that there was so much controversy about, with the Guptas, that the deal should have been done, doesn't the fact that there was controversy about them, didn't that provide all the more reason for you, if you were really genuinely concerned about doing the right thing for Denel and its image, that you should have made absolutely sure that everything was squeaky clean as far as compliance with the law and with procurement policies was concerned?
I take your point, Chair. I can only say that during the single source agreement, I was really under the impression this was something that groups here had the authority to do, that it was in the best interest of Denel, and by 2016, the agreement was in existence, and my view I had then was the horse has been bolted. If there is evidence of corruption, then we've got something to act on. But in the absence of them being blacklisted or evidence of corruption, how do you act on that? And that was my opinion at the time.
Chair, may we then ask for a brief stand down, perhaps around 10, maybe 15 minutes maximum, and then my team will be able to give me their input and we'll be able to complete. I don't believe we should need more than about 10 minutes remaining thereafter. I understand from Mr. Krause that there's at least one aspect on which he has indicated to me he may want to re-examine, but I don't imagine that should be very long.
That's fine. Let us take, therefore, a 10 minutes break.
Thank you.
So coming back at about, well, let's just make it, we'll resume at 5:10.
Thank you,
So
Chair.
that will give you enough some time with your team.
Thank you, Chair.
Okay, we adjourn. Yes, Mr. Kennedy.
Thank you, Chair. Just a few follow-up questions and then we will be done. The evidence earlier relating to officials becoming too entangled in the PFMA, that was a view that was expressed by some legal people. Was that people within your legal department who were suggesting that some officials were imagining that the PFMA was more complicated than it really was? Sorry, just switch on your mic, please.
Correct, Chair, but this was a general discussion. This was not a VR laser specific discussion.
Yes.
It's a general view that was given.
And can you recall who said that?
It was a general view, and if I remember correctly, the head of my legal department, Mr. Denel Governor, also held that view. But I stand corrected. But I'm pretty sure that was a scenario.
Okay. Then you were asked questions about that letter that you sent to Mr. Mlambo, where you referred to Treasury Regulation 16A, etc. How did it come about that you got that advice? What prompted you to get that advice?
The normal practice was that any letter that was written for head office, no, not any letter, in 90% of the time, of normal run-of-the-mill letters like approval for certain things would be written by the person that wants to get it approved. And I would read it, I would make sure I understand it, and I support it, and I would sign it. This letter was one of them, and words in that letter, although it was a long time ago, words that were used in the letter were words like inter alia, which is a typical legal term, and something I would not write. Now, I am fairly sure that that letter was not written, or I would be surprised if that letter was written by Ms. Malashlela, and for that reason, I think it was between the Chief Operating Officer, Mr. Renen Twebes, who wanted to get this contracts placed, and our legal department, Mr. Denel Governor, that letter was constructed, and there might have been back and forth with the letter, and I might have given inputs to it, but the bulk of that letter was written by, and now my guesstimate would be, or I'm pretty sure, by Mr. Denel Governor, most of it with inputs from Mr. Renen Twebes.
Mr. Twebes.
Yeah. And what typically then would happen is I would scrutinize it, make sure it makes sense, and then take it to head office.
And the reason why you went to them for their advice and input was because you and they realized that Mr. Mlambo had to approve this in terms of the policy.
Correct on the last bit of the statement, on the earlier part of the statement. I did not go to them to say, go and write a letter. They wanted, from operations side, they wanted to place a contract on VR Laser. We might have had a discussion, or they just brought a letter to me to say, we need to get approval, and therefore they did know that Mr. Dennis Mlambo must sign it, and presented a letter that, like in most cases, I would go through and sign it off and give inputs if necessary. But I didn't initiate that letter, if that was the comment made.
Right. Can I ask you in bundle 10, still looking at your statement,
Yes,
to turn please to page 646.
6.
Paragraph 86 and 87 at the top. 646.
Apology. I've got it, Chair.
In fact, let's start, if we may, on the previous page, 645, to give it context. Paragraph 84. The reality is that Saluji is himself a political animal. He never cautioned me or Nchepe about our interactions with ESA and VR Laser, and in fact encouraged it. He visited the Gupta residence on more than one occasion. That is more than I can say. It is therefore surprising that Saluji will categorically deny that he instructed Nchepe to manage the relationship with ESA. Not only does it fly in the face of his own testimony, but it is simply disingenuous to suggest that my version in this regard is not correct. I'm certain that Nchepe will corroborate me in this regard. Saluji, and I again remind the reader that Saluji did not have a lot of patience with me as an individual, on more than one occasion told me that my duty as the CEO of a division was simply to ensure that I focus on the implementation of programs and that I should leave the political element and business development to him. Now, is that correct?
That is correct, Chair.
Right. And then the top of the next page, I was therefore not surprised that at the beginning of 2014, he called me into his office and proposed that I give work to VR Laser, as this was a supplier with political clout. He was surprised to learn at the time that Denel had been doing business with VR Laser since at least 2003, and that VR Laser was a very successful supplier in a niche environment. It was Saluji who in 2015 suggested that VR Laser be appointed a single source supplier of complex fabricated structures. Now, of course, you're aware that Mr. Saluji has denied a number of these allegations against him. He denies that he proposed, whether in 2014 or at any time, that you should give work to VR Laser at all, let alone that this was a supplier with political clout. But you were aware, according to your version, as far back as the beginning of 2014, that Mr. Saluji was aware that VR Laser had political clout and was pressurizing or encouraging you to give them business as a result.
Correct, Chair.
And presumably on the strength of that, it came as no surprise to you that the following year, in 2015, he was encouraging you to appoint VR Laser as a single source supplier of DLS.
Correct, Chair.
Now, you gave evidence on the previous occasion that you didn't feel that this was necessarily appropriate, but you left the politics to him. And as it happened, for technical business reasons, not political favoritism or anything like that, but for good business reasons for Denel, you felt it would be a good idea to give VR Laser a single source supply contract. Is that right?
That's correct, Chair.
Yes. But I want to go back to a line of questioning I put to you earlier and ask you, with the benefit of some time since I asked you the first question in that regard, whether you've reflected on it. Whether or not it was a good business idea for Denel to go into a single source supply agreement with VR Laser. I'm talking here about DLS specifically. Whether or not you felt that was good, and whether or not you felt, well, this is a good opportunity, I can now exploit this opportunity to get a supplier that I've always liked and want now. Shouldn't you have actually reported that to somebody? That Saluji had effectively been pressurizing you to give business to VR Laser because of this, what you say he said, political clout. In other words, their connections, not their business credentials. He obviously is accountable for whatever he said. He, of course, denies that, and he will be asked questions in that regard. But what about your own accountability? if your superior, albeit that he had a more senior position in the group than you, and you were accountable to him, surely you're accountable also as an official to the nation at large. And if somebody is making such a proposition to you, which clearly is inappropriate, wasn't it incumbent on you to report that?
Yeah. Chair, I think knowing what I know now, having listened to evidence given supporting that Mr. Salaji was deep involved than even what I thought at the time, it would have been the correct thing to do. I haven't got no doubt in my mind. At the time, however, what I call political pressures and those things, Mr. Salaji made no bones about the fact that he's under political pressure for many things, and that is his domain. And I think over a long period of time, I got used to the idea, or accepted the idea, and wrongly so, that when a comment is made like that, it needs to be supported. If I could have my life over, I would have done that, Chair.
Are you saying that Mr. Salaji indicated to you a number of times that he was under political pressure in the sense that he was being pressurized by politicians to ensure that work from Denel was given to political favorites such as the Guptas?
No, Chair. No, I would not go that far. He didn't elaborate in that detail.
So what did you understand by his reference to his being under political pressure? It's people with political cloud. He's moving in political circles. That he said a number of times to me, and he has to conform to those pressures. I did not see it as anything but you called it favoritism, and maybe it's a good description. I did not see it as any funny business in that regard. But shouldn't you have seen that at least when he was saying to you in 2014, you should be giving favorable treatment to VR Laser because they have political clout? What else could that mean?
Yeah.
But that he was saying to you, people want you to favor them in business, not because they're good, but because they are politically connected. Isn't that exactly what he was saying, according to your evidence?
Yeah. No, you're right, Chair. If it was the only case, then one can make a big argument about it. But it also happened in terms of the Infor business that I had to place on them. So, as I indicated in the previous interview, so it was common knowledge that Mr. Salaji was in general under political pressure. And so it's not just relating to this, but in general. So with the clarity and the advantage of time passing, you are right. I'm not disputing that. At the time when we were fighting the war, I just accepted it. That is the way it is, and it's in principle always been the case. It's not new to Mr. Salaji. There's always been some form of political imperatives that needed to be supported.
Let's understand that clearly, Mr. Burger. You would be able to make a distinction between what he said and what you understood him to be saying. hopefully the two will be in harmony, but they might not be in harmony. The political pressure that you say he generally spoke about, that he was under,
Yes, Chair.
what was your understanding of what he was being politically pressurized to do?
Chair, it's a wide range of things.
That's what I want to hear.
Yeah.
What are those things?
Yeah.
As you understood them.
Yes. Things like the transformation of the organization, the necessity to have deputies and fast track the deputies to senior positions, the decisions to only appoint black female engineers in a very difficult time to get experienced people. And if one argued a different angle to say we've got a program running, it's good to do 80% of that, but let's try and also get experience in. Then the argument was understand the enormity of the political pressure. So those were the more general type, understandable, and I'm not saying it was incorrect, understandable pressures he was under. He also commented fairly regularly that the interactions that he had with certain people of importance, if certain people visited the organization, should be treated in a very special way because of their political position or whatever the case may be. So it was a wide range of things, and in particular, he also said there are companies of importance and with political clout that needs to be supported for whatever reason that may be.
You have, you recall any people that he thought should be treated in a special way when they visited the company? By any chance, do you remember any names, or you never got to know any names? Yeah, individuals.
No, Chair.
No. And did he mention, or you have forgotten, or he never mentioned?
I can't remember. It's 6 years ago, Chair.
Okay.
He might have mentioned. He might have mentioned.
Okay. Okay. And in terms of companies that he thought should be...
So, sorry, Chair, and maybe there was... I can remember there was a company called Tub, and I'm not 100%... I'm fairly sure it was Mr. Salaji that said that it was a company called Tub, and there was a lady owner of that company, and he also referred, and I can't remember her name now, but
Okay.
he did mention her name specifically
That's fine.
as a very important person. So,
Okay. Well, if you do remember later on, you can give us a supplementary affidavit to mention.
will do, Chair.
Mr. Kennedy?
Thank you, Chair. I just have one topic still to raise, and that is after Mr. Mlambo again refused to approve the single source supply contract retrospectively. Did you then take the matter up with Mr. Nchepe, the CEO?
I did not have a discussion with, I can't recall, Chair, whether I did. My argument would not have been, I think we should cancel the single source agreement. I would not have said that.
No,
but based on the inputs given by Mr. Mlambo. Whether I might have had a discussion with him about his I'm pretty sure I had a discussion with him about his discontent with the whole process. So yes.
But I'm asking who raised it with Mr. Nchepe at the level of Group CEO? The fact that there was now a need for a decision. Earlier you said you believed that once Mlambo was refusing to approve, it would be dealt with higher up. But in fact, we know that Mr. Nsepe then signed. He said approved and then he signed.
Oh, sorry, are you talking about the specific T5 contract that was placed?
I'm talking about the single source supply agreement.
The single source supply agreement?
Yes.
No, I took that to Mr. Salaji, Chair. I did not take that to Mr. Nsepe.
But if I can just have a moment, Chair. You can look, please, in bundle 1.
Yes.
Have you got bundle 1, page 824? This is the document we looked at earlier.
Just give the chair. Eight to four. Now this agreement was not the single source agreement. This,
Did you say 824?
824, yes, Chair.
this was for a complex fabricated steel plate that was needed for the T5 demo on the back of the single source agreement.
Yes, but if you look at the second last paragraph, we went through this in some detail. Having identified a need for a single source supply for the supply of steel components and fabrications, in May 2015, DLS signed an MOA with VR Laser for this scope of work. VR Laser is a 100% black-owned entity, etc. Next paragraph. Due to these contradicting positions, supply chain approached DLS Exco to make a decision as to whether to honour the MOA and place the order on VR Laser or to follow up the supply chain policy and procure from Intergroup. Excos recommended that the work be done by VR Laser. So that was giving work pursuant to the MOA.
Correct.
And the MOA was the single source,
Correct.
single supplier agreement.
Yeah.
Yes.
But this request was for the T5 steel plate.
Yes, but it did reflect the fact that the MOA had been found by Ms. Malashlela and later by Mr. Mlambo not to be in compliance with the procurement policy.
Correct, Chair. Correct, Chair.
Yes. So who took the matter to Mr. Nsepe and obtained his signature as approved on the footer page 825?
In all probability, Chair, and I cannot state this 100%, but in all probability, this was brought back to me by Ms. Malashlela, and this was a very urgent requirement because we had to go and do a demo, and I in all probability took this to Mr. Nsepe.
Now, Mr. Mlambo has testified that after he wrote what appears in handwritten form in the middle of page 825, he was effectively ignored. You didn't come back to him. Other executives didn't come back to him. Mr. Nsepe never came back to him. He found out later, through the back door, as it were, that Mr. Nsepe had just somehow approved this,
Yes.
overruled him, and didn't engage in any discussion with him, let alone with you and with him.
Yes, Chair.
You confirm that, as far as your understanding goes.
I cannot recall having a discussion with Mr. Mlambo.
May I just have a moment, Chair? In fact, I'm reminded that Mr. Nsepe himself gave evidence here when he was asked how long it would have taken if Mr. Mlambo's questions and concerns had been addressed and taken seriously, how long would it have taken, for example, to put up a proper business reason? And you said about a day. Can your evidence seriously be correct that there was such urgency to this matter that needed an immediate decision by the CEO, thereby ignoring the group supply chain executives' concerns?
Chair, it's impossible to get a quote on something like this in a day. It's not possible. So I don't know where he got the day from. It's just not possible to set up and do analysis of the drawings. It's a complex drawing. Other people take weeks. I cannot comment on that, but one can argue the fact that Mr. Matlambo should have been taken more seriously, and I've already acknowledged that, Chair. I don't want to go back on that argument, but I can only say, and I say it with a fair amount of shame, that I was convinced that it was the right thing to do at the time. I was convinced that we had an agreement. I wanted to honor that agreement, and I was pushing for the work to be done there because I knew it would come out to be the correct configuration. So, yes.
Thank you, Chair. We have no further questions.
Thank you. Mr. Burger, the answer that you have given with regard when you said you don't know where...
My apology, Chair, I didn't hear my answer.
The answer that you gave to Mr. Kennedy just now, which involved you saying you couldn't get a quote within a day. You remember that answer?
Yes, sir. Yes, Chair.
Was that in relation to page 825, where Mr. Mlambo wrote, made a handwritten note saying DVS and MLT must submit proof that they cannot meet the requirements prior to the contract being awarded to the RLASA, or was that in response to something else?
Yes,
or
Chair.
you're not sure?
No, Chair, I'm very sure.
In terms of what way, was that in the context of that? Because that question arose because, as I understood the position, it was said that there was urgency.
Correct.
That's why what he required could not be given. Is that what you were talking about? Because I'm not sure that required codes if it was in the context of this handwritten note. All he wanted was proof that they cannot meet the requirements. They can't do the job, I guess, is what he meant, as I understand it.
Yes, Chair. When I read his comment, my deduction was both the, well, not DVS, but LMT for sure, would in all probability want to do the work. So they would say they will not supply proof I cannot meet the requirements. They would say, let me work out a quotation, let me speak to my engineers how quickly we can do that. Let's see what the processes are. We'll come back to you with an answer. That is what I read when I read this. I didn't expect LMT to write back, sorry, we cannot make it. Not in my mind. This would have protracted the whole process, and I took this to Mr. Stephan and said, what must we do? With his background in marketing, he knew about the urgency.
As I understand the position.
Sorry, Chair, no. This has got nothing to do with the Badger or the Hoefyster program.
Yes.
There was a deadline for a demonstration in a client's country.
Yeah.
And we had to prepare a gun and usually in a client's country, there's a specific, very, very specific time slot where demonstrations or evaluations, not demonstrations, evaluations are held. And it's usually linked to summer temperature and when the ranges are available. And the timescale on this thing was extreme. So we had to still build the gun, test the gun, and ship the gun. So there was really huge time pressure on this specific program. If it was Hoefyster, I accept your argument, but this one was.
Yes. Mr. Kennedy, you must help me. I may have been misunderstanding. At least you and I have been there with all the witnesses.
Yeah.
Was your question in the context of this note?
It was.
Because now I don't know whether it was Mr. Burger or another previous witness. My impression was that really it wouldn't have made much difference if there was a delay of a few days.
That's my understanding too, and that would have been Mr. Nchepe.
Yes,
Yeah.
but now Mr. Burger is talking about guns and so on. Does that relate to guns?
The demo elements in the first paragraph do relate to guns as we understand it,
Yes,
or something related to gun turrets.
But I mean, I would have thought that Mr. Nchepe would have known if there were good reasons for urgency.
Yes,
And,
he discounted that.
Yeah, he discounted that.
He did. Yes, Chair.
Do you know, Mr. Burger, even within the context of guns that you're talking about, the testing of guns or whatever, do you know what the deadline was as at the time of this memo, namely 29 October 2015? Because
Chair,
if you don't know the deadline, if you don't know the deadline, you might not be able to say that the deadline would not have been met if there was a delay of a week. But if you know that the deadline was within 3 days after this, then you would know that you couldn't afford that deadline. But do you know what the deadline was?
Yeah. Chair, I cannot, the deadline for one thing wasn't the urgency. There was, say, a month later, or I cannot recall, but there was a month or 2 months later, the gun had to be, we actually didn't ship it because of the criticality. We flew it to the country.
Yes.
Because of the urgency. So there was an overall time pressure to make this happen. On top of that, I can recall that after we received the components and we tested the gun, there was a problem in the ammunition feeder for this gun. So then we had to rectify that, and there were extreme pressures.
But the long and short of your evidence in this regard is, I must just check with you, that you know that there were some time pressures.
Correct, Chair.
But you don't know whether those time pressures were such that a delay of a week would have made a difference or not. That you don't know, or do you?
Chair, we almost didn't make it, and the reason was not because of the late placement of this particular item. What happened was we received all the items, we assembled the gun, we took it down to the Cape to get it tested, and it didn't function properly. And we had to redo certain things. So there was, and it almost didn't work. We almost didn't make the ship or the flight for this. But at the time, you could have argued, but in your schedule, maybe there is a week to slot this in, and I would have conceded to you, yes, you are correct, Chair, there is that week, we could have done that.
Yes, yes.
But in hindsight, in this case, given the fact that there was a functioning problem, it was a good thing that we didn't waste time. But I cannot say a week would have worked or wouldn't have worked.
Yes.
I just remember very strongly there were time pressures.
Okay, no, that's fine.
May I just ask your indulgence just to
Yes.
ask a follow-up question just to try and get some clarity on the issue. Ms. Muller-Schleller gave evidence, as I recall, in explaining the memorandum that she wrote at page 824. Do you have that?
Yes.
824. That this was specifically asking for approval retrospectively for the MOA for the single supplier contract. And what she was doing in the first paragraph that refers to the T5 demo was simply reminding Mr. Mlambo that previously he had given approval for the T5 demo. As she says, in giving the approval for the deviation from the normal procurement process and a list of suppliers to be used for the T5 demo, the group supply chain executive, that's Mr. Mlambo, gave an instruction that DLS must first explore how Denel vehicle systems gear ratio and LMT intergroup companies will be used in the project on condition that they meet the quality. Then she reminds him of what appears in the supply chain policy, and then says, having identified a need for a single source supplier for the supply of steel components, in May 2015, DLS signed an MOA. So the first paragraph was simply referring to a historic fact that had already occurred. Namely, he had approved previously the special procurement by way of a deviation for the T5 demo, but subject to specific conditions. Try and deal with them in-house. So she was just reminding him of his approach previously, which said, don't go outside the group if you can go inside the group. And now she's saying, after reminding him of what the supply chain policy says in that regard, requiring a sound business case to be made out, she now says, there has already been an MOA recently in May 2015, 5 months earlier, with VR laser for the single supplier. And on the basis of what you've already, Mr. Mlambo, raised in relation to the earlier approval for T5, and in relation to bearing in mind what the procurement policy requires, may we now ask you for approval? Well, she's saying not herself, but her exco has said, may we now ask for your approval, not of the T5 demo contract, but of placing orders under the MOA for single supply. That's my understanding. Am I correct?
Chair, I never saw it like that. I cannot recall any retrospective request for approval of the single source agreement that I facilitated.
But Mr. Burger, may I take you back to the minutes? If my colleagues can just help me with the reference.
Sorry, Chair. I remember about the conflict between the single source agreement and
Yes.
that I remember.
Yes.
And that because of that conflict, but my understanding was that there's a conflict, so placing an order now, there's a conflict. Can we please get approval to place the order?
Yes. But that's a conflict that relates to the MOA for the single source.
Correct.
And
Correct.
because how people formulated it was, the framework for the debate was, which takes precedence, which trumps the other? Does the MOA trump the procurement policy, or does the procurement policy trump the MOA? Not so.
Yes, Chair, but in the placement of a specific order. That was my understanding.
But in the placement of any order going forward, not
Yes.
so.
Yeah, I do not recall this as being a general paper, and I haven't studied it enough. I have to see it now again. But Yes, because it was a conflict. I remember that there was a conflict between the MOA and the
Yes,
procurement policy.
yes. If I can take you back to the minutes, page 672 in the same bundle.
672.
Yes. Under the heading resolution, the committee took a decision that the MOU takes precedence over the GSCE's condition and the group supply chain policy. Now, the condition related to the T5 demo previously, not so. That was his condition. Correct?
Correct, Chair?
Yes. And the group supply chain policy and the DLS supply chain procedure. And that's why Mr. Mlambo was then approached after this resolution was taken in Ms. Maleshlela's memo. So it's specifically related to requesting approval by the group supply chain executive, Mr. Mlambo, of orders being placed under the MOA single supplier contract. Is that right?
It's correct, Chair, but I thought this was driven by a specific requirement and not a generalistic discussion. I confirm to all of this, but
Yeah.
I was under the impression it was driven by a specific requirement, which was the T5.
Okay, thank you very much. Thank you, Chair. No further questions.
Mr. Klaus, do you still would like to re-examine?
Chairman, I have no re-examination.
You have no re-examination?
No, I don't. Thank you.
Okay, thank you very much. Thank you very much, Mr. Burger, for coming to give evidence. If we need you to come back, we'll ask you, and I'm sure you will come back. But thank you very much for availing yourself, and you are now excused.
Thank you, Chair.
Thank you.
Chair, that is all we have for you in formal open session today. May we then
Yes.
ask for the matter then to stand down? And
Yes.
may I approach you in chambers just to confirm arrangements in relation to the two remaining witnesses in the Denel stream?
Okay, no, that's fine. We are going to adjourn for the day, and tomorrow I'll be hearing that this is for the public benefit of the public. I'll be hearing evidence relating to OEH, the OEH company. That evidence started on yesterday. It will continue tomorrow and for the rest of the week. We adjourn.